Good evening and welcome to this session of the live virtual coaching classes organized by the Board of Studies of the Institute of Chartered Accountants of India. Today we'll be starting a whole new topic, which is possibly more, shall we say, not little advanced, little ahead in the act. Yes, today we'll be talking about prevention of oppression and mismanagement. Prevention of oppression and mismanagement. So this is chapter 16 of the Act. Chapter 16. Maybe you'll be doing the in-between chapters, you see, in the meantime. Since I have certain reorientation, I may be traveling a lot in the end of this month. I'm possibly this topic would be the last topic I will take this month. Then it will be handled by some other faculty. It's a very interesting topic. In fact, I hope you'll enjoy talking about it. And I'm sure you'll be having a lot of questions coming up. So some of you are already logging in and just putting a good evening there. I'm able to see Jana is here. Ms. Jana is here. Mr. Sudhir is here. Mr. Hari is here. So I wish them and the rest of you who are here and who will always come in with queries and questions. I'm sure Boni would be joining us and you would be asking us questions and maybe some more people would come. Let us see. Now, to understand the law relating to, Boni is already, I think Pradeep is also put in his good. So before we can understand the law that is aimed at prevention of oppression and mismanagement, we should first see the shall we say, the cardinal principles governing corporate management. You already seen the power of the board of directors. You also know that the company is the ultimate authority, right? So whatever decision is taken collectively by the company is the decision of all the shareholders. Okay. So that means there should be a certain degree of protection for the minority. But if the rules of meetings, management and administration, rules of meeting have been correctly understood, have been correctly applied, and a resolution has been passed, there is end of it. There is end of it. There cannot be any dispute about it. You cannot go and waste everybody's time rehashing it. This is the essence of the rule in Foss versus Harbottle. Okay? Very old law. Very, very old law laid by the British court. Right? What happened in Foss versus Harbottle? The facts of the case are like this. So if you don't appreciate this case, I cannot even take you into the law because the law, as we know it, the sections that we are going to read are an exception to the rule in Foss versus Harbottle. We'll be seeing the major exceptions to the rule, just as you might have learned the exceptions to the doctrine of indoor management when you studied your intermediate. Here, we are going to see the main exceptions to the rule in Foss versus Harbottle. So, one of those exceptions is your oppression and mismanagement. When the court can intervene, okay, and put an end to the, we'll see that. So, what happened in Foss versus Harbottle? Two shareholders, Richard Foss and Edward Starkey Turton, commenced legal action against the promoters and directors of the company. Mr. Thomas Harbottle and others, including the auditor for your information and the solicitor. Okay. So this Richard Foss and Edward Starkey Turton, two shareholders, brought an action against these people. Friends, important point to be noted. The action was brought by individual shareholders against other individuals. That is why this is Foss versus Harbottle. You don't see the name of any company here. So, what was the allegation? See, in any case, when a plaint is filed, when a suit is filed, nothing is proved until it's proved. So that's why we always say allegation, alleged. Okay, so that unless it is proved, it is allegation. Once it is proved, it is a fact. So in order to make an allegation a fact, you have to produce proof. So as of now, Thomas Harbottle and others were alleging, Foss and Turton were alleging that Harbottle and others had improperly mortgaged the company's property. Right. Now, definitely, Thomas Harbottle and others were in breach of their duty. Okay. But the court rejected. See, definitely they should not have done it. It was not sanctioned by the articles. They acted ultra vires their powers. In other words, the board of directors has acted ultra vires its power. Right. But the point that the court made was, the court rejected the two shareholders' plea. Plea means plaint, like that. Plaint, complaint, or whatever, plea. And held that a breach of duty by the directors of the company was a wrong done to the company, for which it, that is the company alone, could sue. Why? Because company is a separate legal entity. It can file a suit in its own name, defend a suit in its own name. So to be able to file suits in its own name and to defend suits in its own name is one of the important qualities of the corporate entityship. Separate legal entityship means file, sue and be sued in its own name. You learned it long ago. I do not know how long ago. Maybe in college or in foundation, you learned this. Separate legal entity. So this being the case, who are these people? I'll tell you a very simple example. You will understand it better. When I give a simple example like this, you will understand. You and your friend are walking on the road. Okay. Maybe you are walking near the beach, enjoying the sea breeze. Suddenly a third party comes and hits your friend. A third party comes and hits your friend. Now, you immediately get angry and you file a suit against that person in a court of law for assault. It's called assault. When you're physically, threatening to hurt somebody or hurt him, it's assault. Now, again, even if you touch somebody with intent to harm, no, it's an assault. Even if it doesn't cause any injury, just pointing your finger and touching him, gone. He can file a suit against you for damages. Now, who's filing? Your friend was hit. You are filing. Now, your friend comes to court and tells the court, sir, the man who hit me is my father. He has every right to hit me. There's no problem like that. He says, now you have filed a suit. Tell me who can file the suit. Only the person who is affected can file the suit. Now you understand, na? Your friend only can file the suit, not you. When it is an individual, natural person, you are able to understand. Same thing for company also. Who is affected? The company collectively, the wrong done by this Thomas Harbottle and others was company. It so happened in this, one of the facts of this case was that the company has ratified this. The company had ratified the act done by Thomas Harbottle and others. In spite of that, our friends Richard Foss and Edward Starkey Turton went to court. And they filed this case, lost it. So Foss's Harbottle decision was, the individual shareholder will not win. So this was enunciated by Lord Justice Westborn. See, because this went all the way up to the House of Lords. See, in England, the appellate authorities are the Chancery Court, then the Court of Appeal, and then you go to the House of Lords. Just as in here we have the High Court, or you have the, of course, for civil cases, you also have the district courts. And then the lower courts. In anywhere you will have the lower courts where the magistrates are there, and then against the lower court you go on appeal to the High Court, and then High Court, Supreme Court. This is how we work. But there in England, in those days it was the Chancery Division, and then from the Chancery Division we went all the way to the Court of Appeals, and from the Court of Appeals we went to the House of Lords, the Law Lords. They were called the Law Lords. members of the House of Lords who sat and heard the case. They were, see the type of, some of these case laws, just for your information, many of you in your eagerness to pass the exam, you may not appreciate this. But these case laws were decided by really learned men. Lord Westborn, Lord Macnaghten, okay? Denning himself, Lord Denning, a famous jurist, okay? They were all law lords. So and they used to hear these cases and pass the order. Some of them were sitting in Court of Appeal also, some of them in the law. This was decided by the House of Lords and by Lord Westborn, and he says, for alleged acts of irregularity committed by directors which are capable of being ratified and have been so ratified by the majority, no suit shall lie at the instance of an individual shareholder. Beautiful wordings. And even if nothing is going to come out of this in the examination, your knowledge of law and English would improve by reading this decision. How beautifully they have stated it. For alleged acts of irregularity. See how beautifully they say alleged acts. They are not saying, as I told you, nothing is a fact unless it is proved. So what these guys are saying is only alleged. So for alleged acts of irregularity committed by directors, okay, which means we already, it so happens, luckily, I am taking this topic immediately after meetings and powers of directors. So you know that there are certain powers which are intra-vires the directors. Automatically they are intra-vires the company. Means they are within the power of the director. Automatically they are within the power of the company. But there are certain acts which are ultra-vires the director. For example, 181C. 180, for that matter, 181A itself. When the whole or substantially the whole of the undertaking of the company is being sold or otherwise disposed of, then you have to go to the shareholders. So in spite of that, if directors have done it, what happens? It is an alleged act of irregularity committed by the directors. But suppose the majority of that company meet and pass a resolution saying, right, sir, they didn't obtain, but now we are happy with what they did. Maybe what they did was actually good for me. Thank you. So the majority has ratified, which are capable of being ratified and have been so ratified. Be careful, which means one of the fundamental exceptions to this will be where it is ultra-vires the company itself cannot ratify. Therefore, such acts cannot be protected. This rule will apply only to acts which are intra-vires the company but ultra-vires the director, which can be ratified and have been so ratified by the majority. Then no suit shall lie at the instance of an individual shareholder. Okay. This rule is a beautiful rule, and to put it bluntly, if suppose you want me, no, sir, this is very complicated, English mein hai, I'm not at all comfortable, alleged acts of irregularity committed by directors, which are capable of being ratified and have been so ratified by the majority, no suit shall lie at the instance of an individual shareholder. No, sir. Simple. Asan. Majority shall have its way, minority shall have its say. That's all. The majority shall have its way. The minority shall have its say. I mean, very, very crudely put, very, very bluntly put, this is what the rule in Foss versus Harbottle is all about. Simple, because to agree to this, some of you may even get angry. Some of you, your blood may boil and you'll say, how can you say that? Majority shall have its way. Minority shall have its say. Friends, that is the problem with democracy. That is the benefit of democracy also. Democracy works on majority. If the majority says, that's how the whole country will work. There is no other way. If there is any other way, for example, everybody should agree. Think about the mess. How on any issue there will be 2 views against, 4 views for. Those who are for, those who are against 2, majority wins. This is the rule on which democracy works. That is the only way on which it works. If somebody doesn't like it, what to do? The rule in Foss versus Harbottle, we'll have to repeat it. Okay, that gentleman or lady should keep quiet. That's all, or else protest. See, in a democracy, everybody has the right to speak. See, that right of freedom of speech is what makes democracy great. Minority shall have its say. Okay, maybe over a period of time, if what they are saying is reality, and if it becomes popular understanding, maybe everything will change for the better. And you will be having some kind of a thing. But whatever it is, majority shall have its way, minority shall have its say. You might ask me, sir, where is it? prevention of oppression and mismanagement going to come? It's going to come because when can this rule apply? Only when the majority is acting fairly and in the interest of the company as a whole. Maybe the minority's view may be different on what is good for the company, bad, but ultimately there should be no prejudice to anybody. What has done should be beneficial to all. Maybe the way in which it was done was wrong, blah, blah, blah. You didn't like him. That is your problem. But if the majority have acted with a mala fide intention, they have acted with a view to prejudice the interest of the company or any shareholder, then the rule in Foss or Harbottle is not possible. Because only when the majority acts in the interest of the company as a whole, without any prejudice to anybody, the company, any shareholder or the public interest, only then the majority can have its way. Otherwise, their decisions can be investigated. Tribunal has the power. That is how you will enter into this topic. But still, we have not said goodbye to rule in Foss versus Harbottle. Fantastic rule. The rule is based on certain important principles. First, who is the proper plaintiff? Okay. The company is the proper plaintiff, right? The company is the affected party. I gave the example. Now, who is the affected party in that beach story? The man was hit. If he himself is not complaining, if he himself says everything is okay, how can the court entertain a suit from an unconnected third party like you? The court will simply dismiss it. In fact, in law, legal term, this is actually called locus standi. L-O-C-U-S, locus standi, S-T-A-N-D-I-I, standi. Locus standi means right to sue. Who has the... Okay, you've learned it in a different way in contract, maybe. You heard this as privity of contract. Locus standi is a Latin term meaning right to sue, also known as privity of contract. Privity. Who has the privity of contract? Who has the right to sue? Who has the locus standi? The affected party. Give you another example, just to help you, understand this more. See, sometimes I'll just give it as an example in my home city of Chennai, where, we have a lot of these outstation students who come and study. And they come from all over at least all over the southeastern part of our country. They come from right all the way from, I've seen people from Odisha, right up Andhra people will come, Keralites come. So Karnataka, some people come, but they have a better facilities in Bengaluru. So they go there, but still some come to this side. So the point here is Chennai is one of the hub of CA coaching, as you all well know. And they come here and these guys study. So they need not very decent accommodation. For that, they go to an area called Triplicane, where they stay. There are big mansions there, where you get a room, a bed, a table to study, PG. They give you some breakfast, something, then you're on your own. You go around studying, go to from one coaching class to another coaching class, continuously like a hamster in that, wheel. You keep moving from here to there, to there, to there, going mad. Idea being to somehow clear the CA exam and become a chartered accountant, and so on and so forth. Whatever it is, one of my friends is staying in those type of mansion. He is in the 5th floor, window, small room, window. From the window, he is able to see the terrace of the next door in Triplicane. There, every day, evening, one lady, every day in the morning, 11 o'clock, fellow is preparing for accountancy or whatever he is studying, financial reporting, and seeing the window, he sees that lady. She is putting up the clothes, 11 o'clock. She is crying, weeping. And he also, in the evenings when he comes home from the class, he hears huge fighting, and her husband comes home drunk, and he hits her, and he abuses the lady. So our friend, who's studying for CA, but he's also got a social conscience. So fellow goes to the police station, and Triplicane police station, big street man. He goes there and he makes a complaint, and he says, so-and-so fellow is beating his wife, blah, blah, blah. Now, complaint, the police will not take the complaint, but what they will do, they will ask him, sir, you please wait. Then they will call this fellow to the police station, and they will start an inquiry to see whether prima facie there is a case. Now, as this case is going on, what will happen, that lady will come running, and she will abuse this person. You rascal, who are you to pull my husband to the police station? You are rascal. He is my husband. He will hit me. He will kill me. What is your problem? Who are you to do this? See, that is the greatness of Indian women. Okay. Now, why I gave this example again to help you understand who is the proper plaintiff? Affected party. The affected party herself is keeping quiet. Who are you? This is what you have to keep on mind. Now you have to ask, who is the affected party here? The company. Who is the company? This question I used to ask in my classes to my students. This question alone will take some time. By the time you take about 15 minutes because it's very esoteric. It goes to the essence of corporate identity. Please, don't think that I'm wasting your time, but think about it. Who is the company? Is the company the board of directors? No. The board of directors are merely agents. Is the company the shareholders? Could be. Is the company all the shareholders? No, sir. All no. When do you nowhere in the act do you need unanimity? So who is the company then? The company is a majority of its shareholders. The majority. So when you say so-and-so company has done something, you mean to say all the shareholders have agreed to it? No, sir. Only majority. And that too what majority? Majority of shareholders attending a meeting, passing a resolution. Please understand. Those who attend and vote out of that majority. Am I correct or not? Whether it's an ordinary resolution or special resolution, they say the votes cast in favor exceed the number of votes cast against, if any, by members who are attending, either in person or by proxy or through electronic means. Okay? And who vote. Only those people's vote will be counted. Out of that, we have to see how many for, how many against, and you will have your majority. If you want a special majority, whatever it is. Now, so majority of its shareholders decided, that is all company has decided. So the company is the majority of its shareholders passing a resolution at a validly convened, constituted and conducted meeting. See, these fellows sitting at home eating their chapati, they are not company. Only when they come for the validly called meeting, convened meeting, and they form a quorum, and then the meeting is conducted correctly, and they pass the resolution, company has done it. So that resolution having been passed, the company having ratified, then no suit shall lie at the instance of an individual shareholder. So if you accept the proper plaintiff logic, then automatically the remaining two will come. Now, suppose one shareholder can sue, then everybody can sue. Yeah. Think about it. What is so great about Foss and Turton? Why not other people? So what happens? Everybody will file a suit. And there will be multiplicity of suits. And all these suits will fail because of one above. Am I correct? Because one above would mean the company is the proper plaintiff. So ultimately, all these suits will be unfructuous. To fructify means to give fruit. To fructify means to give fruit. To be successful. Unfructuous means unsuccessful. Okay. Now you ask me, why you are saying unfructuous? Why can't you say unsuccessful? Okay. Ask Mr. Tharoor, not me. English language has so many words. Why can we not use such words? Is the question. Okay. So these suits would fail because they will all be unfructuous. It's called unfructuous litigation. So proper plaintiff, multiplicity of suits, unfructuous litigation. Therefore, majority shall have its way, minority shall have its say. One more point. See, when the company is affected, a right is affected, no doubt. As a member, one of my rights is affected. He is doing something, director is doing something which is ultra vires his power. My right is affected. But what right? My right as a member of the company. That is called corporate right. Whereas, suppose dividend is declared and I have not been paid, or meeting is called but I have not received notice, then what is being infringed is an individual right. The person's personal rights are infringed. Where I have required for transfer of shares and the transfer is not effected. These are all violation of individual right. But where an offense is committed against the company, then the right being infringed is a corporate right as a member of the group. So for a corporate right, there is only one remedy. Attend the meeting, vote for or against. If you are against the motion, vote against. If you think it's an important matter, write a blog, send a mailer to everybody, convincing them that they should vote against. And if you succeed, all the great best to you. But if you don't succeed, sorry. because the resolution passed by a majority will be binding on all. Okay. This is something you might want to understand if you're going to become part of any democratic institution. See, obedience is something very important. Once the majority has decided, all of us have to abide by it. You cannot say that, I don't agree, I will walk out. See, this walkout business and all is not correct. It's not democratic behavior. You are part of the group. You have said your say. Voting is what is taken. It is against you. Sorry, that's how the cookie crumbles, and we have to agree. Okay, think about it. This is my belief system. Whenever I am part of a corporate or any association or any group, I will do my best to convince the group that there is another way of looking at it. But consistently, if the majority wants to do it, then let them. I have to. Walking out is not a correct approach. Walking out of the place, not a correct approach. You have to sit there, be there, pay respect to the chair, and then after the meeting, maybe you might want to take a call to leave the association or to quit your association with that association. That comes later. But walking out of the meeting, abusing the chair, shouting, these are all not parliamentary behavior. It's unparliamentary behavior. Okay. Right. Now, I told you that we'll be talking about exceptions. Okay. So, exceptions to the rule in Foss versus Harbottle. One, which I mentioned already, where the acts are basically ultra vires the company and illegal, and hence not capable of being ratified. Okay. The acts are basically ultra vires the company. Company itself cannot do. How can the directors do that? Even if the directors have done it, which is ultra vires the company itself cannot ratify it, boss. Your Ashbury rail carriage versus Rish, not even all the shareholders there. Not Lord McNaughton says not even all the shareholders can, ratify act which is ultra vires the company. Ashbury rail carriage versus Rish, okay, and hence not capable of being ratified. There are some small corrections. Let me make it on the hoof as we are doing it, because I see that it's on unfructuous litigation. Okay, and here I would humbly crave your indulgence to permit me to change this. A small change, no doubt, but important, because an act may be ultra vires the company, but not necessarily illegal. So, but all illegal acts are ultra vires the company. Ultra vires in the sense, it's not supposed to be done. So nobody can do it. Company also cannot. Okay. So Jana is suddenly putting up a single sentence. Company as a separate legal entity. I agree with you, madam. That is what I've been telling from the beginning. Okay. So the sudden statement made by Ms. Jana is giving me a thought. Okay, I don't know what she is trying to communicate. If it's merely a statement of a fact, I agree with her. I cannot do anything but agree with her, help agreeing with her. Okay, good. Now, so since the company has a separate legal entity, it can file a suit in its own name. Therefore, if it has not filed the suit but has ratified the act, then individual shareholder cannot file a suit. Hope you have understood that cycle and closed it. Okay. Now, where a special majority is required and it is alleged that such majority has not been obtained, though a simple majority has agreed. Simple majority means number of votes exceed. Okay, here is the small quiz for all of you here. I'm sure you know the answer and I'm wasting your time, but still. What is a special resolution? Under the Companies Act, what is a special resolution? When will you say a special resolution is passed? I'm looking forward to your answers. Yeah, Mr. Srivastava, example of ultra vires means beyond, yeah. See, the powers of the company are defined in the memorandum and articles and the Companies Act. Anything which is beyond that or which is contrary to that is ultra vires. The good old ultra vires rule, doctrine of ultra vires. So if it is ultra vires, the company, doctrine of ultra vires, even it is void here. In which case, the directors can be sued individually. Are you able to understand? Individual shareholders can take action against the company. The directors were doing something ultra vires. You see, this is your fault. You pay us. Like that. Right? It's something that you can do. The company is not bound by such acts. First of all, the company is not bound. If the money of the company has been used by the directors for such an ultra vires act, that can be recovered from those directors. That cannot be ratified. That's the point. If the company does not file a suit, individual shareholder can file a suit. I was waiting for this. I was waiting for these answers. Let me wait for some more answers to come. Pradeep has given nice answer. 2/3 of voting majority. Okay, let us see. Some more answers. I don't know. A lady called Dara Shah used to be very active. Now she is not. Vote in favor is 3 times. My friend Aniket Jain, welcome, sir. Vote in favor is 3 times the votes against. Maybe you should add only one thing there. Because the way you've written it, Aniket Ji, it looks like exactly 3 times. Suppose it is more than 3 times. Of course, you may not have had the time to type it out, but then. So Pradeep says 2/3. Molly Shyam Kumar says 75% in favor. Kodali says 75% of votes for the resolution, whereas simple means exceeding for or against. Beautiful. All of you seem to have a handle on this, but somewhere I'm with Mr. Aniket, subject to that correction I suggested. The number of votes, see, actually the section which defines this is very clear. It says the number of votes cast in favor by members present and voting. No, that is majority. What is special majority is what I'm asking. Shailendraji is giving me simple majority, means more vote favor than against. Yeah. The number of votes cast in favor exceeds the number of votes cast against, if any, then simple majority. See, the problem with 75% in favor, etc., is it doesn't reflect the words of the section. Only Aniket has given broadly the section. Others are sort of 2/3 is nowhere. You will not find 2/3 anywhere, Mr. Pradeep, in that section. Okay. I think it's 115. Correct me if I'm wrong. Or 112. Correct me if I'm wrong. I'm not very familiar with section numbers. If you want, you can refer to the section number. Why I am asking this question? No. Even see, special resolution, many people don't know. They will give 2/3 majority, 3/4 majority, 75% in favor. Like all these words will come. 2/3. Sudeep, where you guys get the 2/3, I don't know. 2/3 is not there in that section. Okay. 2/3 is not there in that section. Maybe, yeah, Jai Srivatsava now comes with 3 times or more of votes cast against or in favor. Sir, you read your own sentence. If you understand it, I will be happy. 3 times or more of vote cast against or in favor. 3 times of. Sir, 75% is out. It's not 75%. Okay, I'll give a simple question. If you answer that, then you will know. There are, see, 5 members attend. 5 members attend. Only company has only 5 members. All are attending. 5 members, all are attending. Vote on show of hands. Voting on show of hands. Nobody is calling for a poll. 5 members attend. 5 members attend on a matter. Voting is called by chairman. Show of hands. Show of hands, 1 person, 1 vote. So, 2 people. Yeah. 3 people for. 3 people for. 1 person against. 1 person neutral. Have I passed a special resolution? Five people attend. 3 for. 1 against. 1 neutral. He doesn't vote at all. Have I passed a special resolution? Now you will find your 3/4 is coming there. See, because the neutral fellow will not be counted. Remaining 4, 3 for 1. Okay, so you will say, sir, 75% have voted. Therefore, 3/4 majority. So 3/4 is 75%, right? So you will say pass. Now I am asking another question. Yeah, yes, it has passed, but the way you arrive at is different. 2 people attend. Rather, okay, 3 people attend, 2 in favor, 1 is neutral. 3 people attend, 2 in favor, one is neutral, no votes. Special resolution have I passed? 3 people attend, 2 in favor, 1 is neutral. Have I passed a special resolution? 3, only 2 people vote, both are in favor, 1 is neutral. Have I passed a special resolution? You will again say yes. Correct. Now here comes the clincher. 2 people attend, 1 in favor, 1 is neutral. Have I passed a special? 1 is against. Okay. Have I passed a special resolution? 2 people attend, 2 people only in that company, both attend, 1 in favor, 1 against. Have I passed a special resolution? Last one is the real clincher. All along you have gone, yes, yes, yes. Now tell me. 2 people attend, 1 against, 1 in favor. Have I passed a special resolution? See, the number of votes cast in favor should be not less than 3 times the number of votes cast against, if any. This is the rule. The number of votes cast in favor should be not less than 3 times the number of votes cast against, if any, by members present, either in person or through proxy or by electronic means, or voting by electronic means. Okay. So, members present and voting, either in person or through proxy or by electronic means. The number of votes cast in favor should be not less than 3 times the number of votes cast against, if any. See, how many votes are cast against? 0. Into 3, 0. Number of votes cast in favor, 1. More than 3 times the number of votes cast against, if any. Okay. So this, that way, yeah, in the last example also the special resolution has been passed. That's what, see, I know you're all giving me no, because you're trying to defend your 75% concept. Okay. Those of you who think it's 2/3 majority, 75% and all, please read the Bare Act. Actually, our institute material, if you read intermediate, is straight away institute material is only the Bare Act. So you can read it. Or else if you want horse's mouth, go to Bare Act. And see, in fact, I even use this opportunity, with your permission, to show you the Bare Act. Let me show you the Bare Act. See, this is the Bare Act, but the problem is, sometimes this thing creates a problem. So this is the MCA website. This is the website of the Ministry of Corporate Affairs that I'm showing you, wherein, the latest Companies Act is there, very much there. Okay. In fact, sometimes it comes to me, it comes. Sometimes it does not. They keep giving all sorts of problems. One sec. Ebook. Okay. This is a lot of laws are there. You got it. Now let me go to your management and administration. So drop down. Therein, I think it's somewhere in that 112 category. Ordinary 114. Sorry. So I'm 0 on section numbers, Baba. Please. Once upon a time, long ago, I used to be thorough with section numbers. Today, main Buddha ho gaya. It's not worth for me to remember. If it is coming in, it's okay. But you can't say that because you have to write the exam. I'm not trying to memorize these numbers. Let us see. Ordinary and special resolutions. Let us see. 114, right? 114. Once you click on it, it will come. You can see that. Very simple, short and simple section. Let us see. A resolution shall be a special resolution when the votes cast in favor of the resolution, whether on a show of hands or electronically or on a poll, as the case may be, by members who being entered so to do vote in person or by proxy or by postal ballot, are required to be, actually, see English, shall be, that is all simple. Instead, they say are required to be not less than 3 times the number of votes, if any, cast against the resolution by members so entitled to voting. So kindly remember that it is 3 times. Okay, 3 times. Okay, so those of you who are still having the view of 2/3, 75% and all that, kindly remember 114 is the operative section. I have shown it and it is okay there. Yeah. So good. Wonderful. So I thought I will see, you know what happens in Tarka, you know, when we are Tarka means debate. In debate, there are 3 ways of proving it. Okay, I can prove it by an argument, that is Tarka, or I can prove it by Anumana, that is where I can give you some examples, or by some logic, and I can tell you, hey, this is how it has to be. But sometimes logic fails. Tarka is merely you and I fighting with each other. Finally, we have Pratyaksha, where, you know, I show you. That is how it is. I show you with the proof, with the bare act, I've shown you. So after that, you know, there can be no Tarka, right? It has its Pratyaksha. It is in front of your, the act is in front of your eyes. Now your knowledge has improved. Normally, I wouldn't waste your time asking you for special resolution. But humble suggestion, please do not assume any definition. Please read the bare act or the authentic content and become thorough with it. This is especially so when we are dealing with... So just to give you the further clarity, by this definition, go back to my last question. 2 people attend, 1 votes, 1 against, 1 for, have a passed a special resolution. So what is the formula? The number of votes cast in favor shall be not less than 3 times the number of votes cast against. Votes cast against how much? Oh, I'm so sorry. I made a mistake there, right? I'm so sorry. Sorry. 2 people attend. Sorry. 2 people at my mistake. I think Jayasri Vatsava corrects me. Correct. 1 should be neutralized. Correct. That is no votes against, 1 neutral, 1 for. Sorry, my mistake. That is why possibly you got confused. Anyway, so 2 people attend, no votes are cast against, 1 is neutral, he doesn't vote at all, 1 votes for. Have I passed a special resolution? Yes. Why? Because number of votes cast against is 0. 0 into 0 is still 0. I'm sorry, 0 into 3 is still 0. So number of votes cast against is 0. 3 times is 0. Number of votes cast in favor is 1. 1 is greater than 0. Therefore, cast. I'm so sorry. The way I said it was wrong. I'm correcting myself. 2 people attend. 1 is neutral. 1 is for. No vote against. Have I passed a special resolution? Yes, I have. Whereas if 1 is against, I have not passed a special resolution. Why? Because same logic. 1 into 3 is 3. Whereas 3 is greater than 1. So I have not passed. Okay. Thank you for patiently listening to this. But please understand that somewhere, law is not, you can't just casually say this. Better be careful. This is especially so, see, company law is fairly simple. You can actually master it. Income tax is more complicated. It keeps changing every year. And that too, you have to remember a lot of things like the deadlines, from which date it became effective, limits are there, percentages are there. So these keep changing. Up to a particular date, it is one. Beyond that, it is not. So there you have to be even more careful. Which is why you might have seen when you saw my Google screen. Not only is Companies Act there, income tax is also there. See what is that so-called the income tax department? That department website is also there. Okay. Nowadays, in my office, we've stopped buying the bare act books. I do not buy the books, whether company law or any law. I don't buy the book because the entire bare act with the amendment, with the notification, etc., is available in Taxman for income tax. Even company law is available in Taxman. Or else company law is available for free in MCA, for free in incometax.gov.in for poor people like me. So we can just go there and we can see. But of course, I prefer Taxman because I'm a tax practitioner. I need to have case laws also. So we have an annual subscription to Taxman. Not that I'm recommending Taxman. And I also, if at all I'm going to buy any book, in income tax, I buy a book written by a man I really have appreciation for. whose book I used to read right from my intermediate income tax exam. I only read that book. It's written by a great man called Vinod K. Singhania. Vinod Singhania ji is the best. Of all these guys, Singhania is the best. It's accurate, and it's simple, and it's well written, and it's nicely tabulated, and I find that it's very level. So this I thought I will share with you. Vinod K. Singhania is the best. No, see, suppose a client comes to me, or a client has an issue, say capital gain, or claim of say 80 JJAA, or claim of 80 IAC, whatever it is. I have to take a call on provision for taxation in a statutory audit, whatever it is. First step, I will read the Bar Act. Because I'm a chartered accountant, qualified man. I will read the Bar Act, read the related sections, put it all together, form my opinion. Then refer to Singhania ji for whether he has any other view than me. If so, maybe he has got some reasoning for it. I will check up. Not much. Then that is my opinion. This is how I work on taxation issues. Any legal issue when clients come to me, because clients always come to you with problems. Okay, they don't come to you with a clear-cut subject-wise clarification. They don't say, sir, this is company law question, this is income tax question, this is whatever question. They come to you with the problem in a bundle, they will throw it on your table, and they say, give me a solution. So the solution could, straddle law. There could be an impact in company law. There could be an impact in maybe disclosures. There could be an impact in income tax, of course, taxation. Everything has to be taken, and we have to give them a solution. This is something that I want to stress to you, because going forward, this is the skill that's very, very much needed. Sorry for the extreme sidetrack. Out of context, I have gone. We were walking along a path in the forest. I saw a deer. I went in and I really circled. But what you did not notice was throughout I was turning left, so that we are back on the track. Okay. And we are back on the track, and we are now back on our researches into the rule in Foss versus Harbottle. So the whole thing, we took off with that special majority, and I hope some of you would have enjoyed the deliberations and maybe got a little bit of additional knowledge out of it, which may be there. You'll be very surprised. You might ask me, sir, this is all intermediate syllabus, sir. Why are you wasting our time? Correct. Maybe I am. I stand corrected and I apologize. But you'll be very surprised as later on as a practitioner or as a senior executive of a finance department of a large company. This is something you can catch out even company secretaries. I'm not joking. Of course, maybe I've exceeded my limit there. Maybe company secretaries should not make this mistake. Generally, chartered accountants will not know. They will again go back to your good old 2/3 majority, 75% majority, all that they come. Okay. See, small ways you can establish your superiority by quoting, like Rashmi was saying, section 114. This is what it says. Oh, wow. See, some of our premium, we get as professionals, we get our premium by the way we present ourselves and the way we present our answer and our knowledge. So you should show to the world that you have the knowledge. You have to articulate it. Then only it will be seen. Possession is one thing. Articulation is the key to professional success, which is what you have to pick up when writing the answers in the exam also. Now, okay, sir. We also saw the individual right. So when an individual right is violated, there is no problem. You can file directly. You can file a suit. You can even file a suit against the director who has, caused the loss or whatever. And but if you want to remove your director, you can't do it. It's a collective decision. You know that. How to remove a director, we saw. Finally, we come to the point. At last, we come where any act amounts to oppression of minority or mismanagement of the affairs of the company, it is a clear exception to the rule in Foss versus Harbottle. If the majority has acted mala fide, with mad intention, without any good intention, their intention is to make additional profit or mismanage the company, then if the act amounts to oppression of minority, or but again here Foss versus Harbottle, they say minority, but in Companies Act, no need for minority. If there is any oppression of any member or members or mismanagement of the affairs of the company, Straight away forget rule in Foss versus Harbottle, move on to the topic. Okay. This is my guru. For just, sometimes I share this picture with my students because the man sitting next to him is me in the suit and red tie, the company secretary institute tie. Because this was an occasion when my guru, Professor K.S. Anantaraman, who is no more, he passed away in 2014. 14th August 2014, he passed away. One of the greatest teachers of company law. And his book is a legal classic, Lectures on Company Law and Competition Act, written by him, is a legal classic. Okay. So I take this opportunity. Sometimes this class comes on Thursday. It will be a greater honor for me to honor my guru. Now even though it's Friday, I'm taking this opportunity to introduce you to my guru. So if some of you say, I am your guru, then this is my guru. The man who taught me company law. The man who made me a teacher. You can see him here, Professor K.S. Anantaraman. Now, how is he connected here? Because Professor, when he wrote the book, was a great fan of the rule in Foss versus Harbottle. And when he wrote the book, at that time he was reviewing the case laws, and he found in 1998, when he was reviewing the book in 2000, in his edition, he found that there is a case law decision of the Supreme Court in ICICI Limited versus Parshrampuria Synthetics. Okay, where the Honorable Supreme Court has said the rule in Foss versus Harbottle should not be mechanically applied. Okay, to all Indian situations, Indian conditions, and they said you have to take into account the Indian corporate realities. So merely mechanically applying Foss versus Harbottle without considering the realities of Indian corporate realities. See, what does Foss versus Harbottle say? Rule of majority. Okay, so he quotes it because it's a textbook. Professor quotes this case law, ICICI Limited versus Parshrampuria, and he says, yeah, this is what the Supreme Court says. But then he says, the rule in Foss versus Harbottle is a rule of convenience and expediency. It prevents multiple suits and infructuous litigation. Therefore, this rule should have universal application. This is a opinion expressed by my guru, which I share, that merely because it is a British case, we need not reject it. Foss versus Harbottle. See, many British cases still have value. For example, your Ashbury Rail Carriage versus Reach, your Turkand versus Royal British Bank of versus Turkand. These cases, Turkand's rule as we call it, these are still valid. They're still valid. They cannot be taken away. But having said that, this is a Supreme Court decision which says apply the rule carefully, especially where, though apparently the majority seems to have acted, still, if there is an oppression or mismanagement, then the rule cannot be applied. Okay. So now with this, shall we say, broad introduction to the rule in Foss versus Harbottle, I am jumping into the section 241. The first of these sections begins, okay, with application to the tribunal or tribunal or whatever you say for relief in cases of oppression, etc. Okay, oppression, etc. 241 1A. So how do they say? Any member of a company may complain that the affairs of the company have been, I've circled have been because in the old law, this was not there. Okay. So in the old law, this was not there. 396, 397. 396 oppression, 397 mismanagement, 399 requisite majority. Old law. Now 241. So 241 1A says, any member of a company may complain that the affairs of the company have been conducted or are being conducted in a manner prejudicial to public interest or prejudicial or oppressive to such member or any other member or prejudicial to the interests of the company. Which is why when I mentioned prejudicial, I included public interest also. Now they have included public interest. Earlier, in the old law, it was simply said, any member may complain that the affairs of the company are being conducted in a manner prejudicial to any one or more of themselves. Okay, that's all. Now they have widened it. They said have been conducted. Even past acts are now covered. Earlier, past acts were not covered. Now they're saying even a past act you can complain now. But you need not establish that the oppression is present and continuous. It is even if you can show a past act of oppression, you have a case. Okay. But it could be continuous also. Okay. Oh, thank you, Mr. Sudhir. Thank you. I'm so happy that you are recognizing my guru. Good. So, see, these are the small traditions of our ancient country that we should, I feel these are the things that make us essentially Indian. Okay. However much westernized we will become, however much, modern we will become. I have nothing against that, by the way. Still, at the core of us, we are Indians. And one of the traditions in India is to salute the Guru, our Guru. So, which is what I did now. Thank you for that heartening words from Jana and Sudhirji. Thank you very much. Now, going on. Okay. So, from this wordings, I only taken the sentence wordings from this section and I have represented it for you. I'm able to understand any member can complain. Which means even the majority can complain. Not necessarily the minority. Even the majority can complain. So long as the conduct of this being in a manner prejudicial. Maybe the minority group has taken control and they are running it. Majority is not able to do anything. I can give you an example. You will understand it. I will give a real life example. You will understand. Not mention the name of the company because I was involved in that. But long ago. Long ago. 90s, 92, that time, 91, 92, like that. Almost when I started my practice, early stages of my career. Okay, let's come to the point. Now, when I come there, I will tell you more about this. I'll give a case study example on how oppression mismanagement can happen. Even majority may have a problem. And all. Now, the Act does not define the word oppression. Okay. Maybe if you want some type of a definition, you can say anything done which is prejudicial to public interest or oppressive of any member of members or prejudicial interest of the company is oppression. But again, they use the word oppressive. So we have to understand the word oppression has not been defined here in the Act. But so we have to understand it in its general meaning or as understood. So in a famous case law, again reiterated in Shanti Prasad versus Kalinga Tubes, oppression has been explained in this way. See, the essence of the matter seems to be that the matter conduct complained above at the lowest level involves a visible departure from the standards of fair dealing and a violation of the conditions of fair play, on which every shareholder who entrusts his money to the company is entitled to rely. Okay. Now, it is also seen that the burden should be harsh, unjust, or tyrannical, where, it is very difficult to bear. It is also given that the unjust act must be done persistently, though today have been is used. So even in the past, isolated act should be. But again, you can't take one single isolated act and then come back and say, he's, in those days, 5 years ago when I came, he did not. Still, there should be some persistency about it. The act should be something. So, it should be continuous course of conduct that is harsh. But it could have been in the past, not necessarily that it should be present and continuous. 241(1)(a) deals with oppression. The old law was 397, if I mentioned to you. 397, 398, I told you. 397, 398, sorry. And 397, 398, 399. So not 396. 396 was amalgamation in public interest. Sorry. So 397, 398, 399. 397 of the old law, oppression must be continuous. Past acts of oppression will not entitle plaintiff to seek remedy under 397. But now, the words have been are used. Then oppression can be past or continuing. Also, majority may also sometimes be victimized. See, one more point you will see is this word any member is used, which is important, which means any member, not necessarily a minority. Please remember, the law fixes a lower limit. That is, a minimum number is needed for petitioning. But no upper limit has been fixed. Unlike small shareholders, we say not more than 20,000. To define a small shareholder, we say a shareholder, the face value of the share is not more than 20,000. Becomes a small shareholder. Unlike this, there is no such definition of higher limit. They said anybody can apply. Even a guy who's holding 60% of the shares would be above the lower limit. Now, he is entitled to apply. So, majority may also apply is the point that comes to our mind. Any member. Okay. Also, you will find that there is a lower limit fixed, but no upper limit fixed for who can apply. There is no cap which says such a member who is holding more than 70% cannot apply. Nothing like that. Any member. Oppression includes acts which are conducted in a way prejudicial to the public interest. So this was not there in those days. Now it is there. This includes not only shareholders, but also the economic and social policies of the state. For example, if there is some kind of a defalcation at the cost of GST, see GST funds are being siphoned out of the company. See, they are collecting GST, not paying it. 3-4 months GST is there, gone. And the MD has bought a new Chevrolet car. New Ferrari, whatever. Okay, obviously cash flow, yeah, come on. Where did this money come from? He took the money from the company. Company did not pay GST. That means you are violating GST law and you are getting him a new car. So clear case of mismanagement and oppression, right? Prejudicial to public interest also, you can see. But the majority is controlled by him, therefore he does it. Still, there you cannot say rule in Foss is Harbottle, because what he is doing is prejudicial to the public interest, prejudicial to the interest of the company, and also oppressive and prejudicial to the interest of any member or members, the applicant himself or any other member. Now, let us move on to some examples to help you to understand oppression. 60% of the shares of Indo-French Limited are held by a French group and balance by an Indian group. As per the Articles of Association of the company, both groups had equal managerial powers. Though the French group had 60% share, managerially they had equal rights. Okay. Equal managerial power. The relationship between the two groups soured, means became bad, and the operations of the company reached a deadlock. The Indian group approached the NCLT for action against the French group for oppression. Whether the contention of the Indian group that the foreign group is acting in a manner oppressive to the Indian group will sustain. Okay. What relief can the NCLT grant to the petitioners in this case? Now, see here, this entire problem is based on facts. Before we go here, let's answer Mr. Srivastava's question. Public interest is exception to locus standi, not standing, locus standi. After the D, you put 2 I's, locus standi. No ing, I, locus standi. Not really. You are a public. Are you also not a public? Yes. So don't you have a locus standi as a public here now? So when public interest is affected, you are having locus standi as a public, as a shareholder and as a public. But who is affected? General public interest is affected. Who is filing a case? Who is filing? Member. So the member is also public, right? But only in his capacity as member he can file, even though public interest is affected. Good question, actually. See, that is what happens when these MCA fellows start meddling with the old law. Old law was very clear, because you actually, a good question, Srivastavaji. As usual, your working thought. I'm happy. See, think about it. If public interest is affected, who should actually be affected? Who should be the protector of the public interest? The central government. Now, central government can always petition. Central government can always do many, many things. We are going to see that also. Right? But members can also complain if public interest is affected. Okay. So this is not exactly an exception to locus standi. It's a sort of a broader view of locus standi, where I am also a public, like that. So, of course, you see, you have not studied investigation. I don't know if you have, or if you have, you will understand. See, you can always go to the, central government also. And central government itself can protect your public interest. Anyway, good question. Moving on. So here, this entire problem revolves around the facts of the case. And one of the important facts is that the two groups enjoy equal amount of managerial power under the articles. Due to misunderstanding, there is deadlock. In a situation like this, where the rival groups are equal in strength, there may be no oppression. See, for you to have oppression, one fellow, see like that red t-shirt fellow, obviously, he's frightening that small guy there. See, such a difference should be there. Otherwise, how can you say oppression? Suppose we are both equal. He says, he's hitting me, sir. How can he hit you? You are also having stick. You also hit him. Who's preventing you from hitting? You are having equal managerial power. Why you need my support like that? Okay. Now, this view is supported by the decision in Jnana Sambandham CP versus Tamil Nadu Transport Coimbatore Private Limited. Further cases of deadlock may not be a case for winding up. At best, the tribunal may direct either group to buy out the shares of the other, and failing which, the company may be wound up on the grounds that it is just and equitable to do. This particular part you will understand when I come to relief for oppression, or rather, when how central government can act. There they have to show that the oppression is of such a nature that it is better that the company be wound up. Then the tribunal, without winding up the company, may give such relief. But this is not deadlock is not a fit case. Okay. They can as well ask one group to buy out the shares. Only if that is not done, then only that company can be wound up. So that being the case, this may not work out as a case for oppression. Okay. As the two groups are equal in strength, there is a deadlock, there is no oppression. If at all the NCLT decides to grant relief, it may order the foreign group, which holds 60% of the share capital, to buy out the minority group. This decision was taken in Yashovardhan Sabu versus Ross-Beckett Sabu Limited. Okay, where they said, see, after all, what is the problem? You buy out. So the foreign company can buy out these people and say, hey, they are not happy with what you are doing. They want to go out, buy that share. You run the company. These are all powers available with the tribunal. Later on, when we come to the powers of the tribunal, you will understand that these are powers. Maybe when we go to the powers of the tribunal, we'll again revisit this problem. When you know it will be more meaningful to you. But before we go there, I want you people to look at the way I have presented this answer, right? I have clearly given three distinct parts. There is a fourth part also, which I would normally include when I'm writing the answer in the exam. That is, first I have represented the facts. Then usually, if I'm writing the exam, here I'm not wasting the space there because you already know the law, right? So if there is a specific section, I will write that section. If not verbatim, at least broad content I will write. Now, applying the law to the facts and then conclusion. Okay. Jana makes a very valid point. She says even the minority can sue, majority can sue. But here, the issue is it oppression? That's why I'm bringing this problem here, where I'm defining oppression. I want to bring it. The conclusion is that it is not oppression because both have equal managerial power. Merely because one fellow has 60% doesn't mean that the 40% wala has no power. Because as per their agreement, they have equal managerial power. That is the reason why this may not be treated as a case of oppression, right? Yeah, Jenna wants to say that it will be, that's why we are finally giving the suggestion. If at all NCLT decides to grant relief, then if they agree, okay, what they are doing is prejudicial to there is no prejudice to the public interest being seen here, but there could be prejudice to any members, maybe these 40% fellows. One of the powers of the tribunal later on you will see is, instead of winding up the company or, they can say, 60% fellow, you buy that fellow. By the same token, they can tell the 40% guy to buy the 60% guy. Both will be given an equal opportunity. A registered valuer will be called. He will present a valuation report. Then there will be objections by both the group. Finally, he'll say, hey, what is the price? Negotiate. Come on. This is the price. You want to buy, buy. You want to buy, buy. Take over. You run. If you think you are good, run. Is the point. Okay. Now, application to the tribunal in cases of mismanagement, not oppression, mismanagement. Okay, so this is basically, actually the title is oppression, but this is mismanagement. That etc. is mismanagement. So since I put it here, now you will understand. So this is when application can be made to the tribunal in case of mismanagement. So oppression is one type, mismanagement is another type. Here again, any member of a company may complain that the material change has taken place in the management and control of the company. Friends, unfortunately, I'm a purist in the use of the English language. Now, here, the use of the definite article, the, seriously doesn't, I'm not able to understand why they will use the word the. The correct word to be used here would be a. Because at this point in time, it's indefinite. Yeah. What type of change? See, the means known, the material change, about which I spoke earlier. Here, you have not spoken about any material change. This is the first time you are talking about it. Then, any member of a company may complain that a material change. But unfortunately, the section uses the word the, and I'm reporting it verbatim here. But the purist in me is unable to accept this usage of the, shall we say, misusage of the English language, right? So anyway, material change has taken place in the management and control of the company, whereby there is an alteration in the board of directors or manager, or in the ownership of the company shares, or if it has no share capital in its membership, or in any other manner whatsoever. Okay, so the material change has taken place, whereby there is an alteration is there, or the ownership of the company is changing. Because of this, and by reason of such a change, it is likely that the affairs of the company will be conducted in a manner prejudicial to its interest or its members or any class of. Here they don't talk about public interest. Here they are only talking about interest of the company, interest of any members or any class of them. So the sequence is a material change has taken place, means an acquisition or a sale of share. Something is happening, because of which there is an alteration in the board of directors or manager or in the ownership of the company share or in its membership or in any other manner whatsoever. Okay. And because of that, it is likely that the affairs of the company will be conducted. The future is indicated. Manner prejudicial to its interest or its members or any class of. So, one quick point I'm able to understand about this is, oppression is about past acts or continuous acts, right? And relief is being given to cure the problem. Whereas mismanagement, it is likely that, so the future is being indicated here. Therefore, it is trying to give preventive. 241(1)(a) is curative. Already the oppression is there. We will cure it by removing the oppression, by doing something to remove the oppression. You are already in pain. I will help you to relieve that pain. Here you are saying, hey, it is likely that the affairs will be conducted prejudicially to me later. So we are trying to prevent it from happening. You have to show how this change in the ownership will materially change, how it will affect you. Once you are satisfied, we can put an end to it, right? Now, so this is oppression, this is mismanagement, right? 241(1)(a), 241(1)(b). Now, how do you apply? The application should be made to the tribunal, either under 241(1)(a) or B. 241(1)(a) or B read with 244, because 244 gives the requisite number, the members having the right to apply under section 244. So 244 gives the requisite number of persons who can make an application for relief in cases of oppression, etc. So if the number is satisfying, then they can directly apply under 241 1A and RB. But the central government is of the opinion that the affairs of the company are being conducted in a manner prejudicial to public interest, then directly the application can be made by central government. That is under section 241(2). Now, this will directly answer your question, Mr. Srivastava. Who is having the real locus standi? The central government. Who is the protector of the public interest? That gentleman, that group has been given directly 241(2) power to approach the tribunal under 241(2), where they are of the opinion that the affairs of the company are being conducted in a manner. No need for any requisite member, nothing. So once this is there, why this thing, public interest, is included here? GOK. God only knows. These fellows will do like this. Anyway, you are given the power to the central government. Who is the protector of the public interest? Let him go. Why are you bothering? Only when it is prejudicial to the interest of the company or to the interest of the members or member, 241 1A and B. So that way, J. Srivastava has asked a very beautiful question, for which the answer is there in 241(2). Public interest is exception to locus standi. It looks like that. Because as you rightly asked me, member, how does he have locus standi for public interest? 1. 2, even assuming he's suing as a public, then can any public sue? Because if you say public interest means every public is involved, then every public can sue. Sorry, that is not the intention. Only member can sue under 241 1A and B. So where is this locus standi? Again and again we are circling. Whereas the group that has the locus standi are the central government, the so-called officers of the Ministry of Corporate Affairs. They have the right. So they have been given power under 241(2). Why are we then giving? So as usual, one more confusion created by our great guys in the Ministry of Corporate Affairs, for which we eternally thank them. Simply why they are doing. That is why when students ask me logical questions on the current law as it is now, I'm unable to give logical answers. When an intelligent boy like boy, man, whatever, I don't know, sorry, like Mr. J. Srivastava asked me a question, I'm unable to give him a reply, except to bullshit around. But if you ask me honestly, you're right. It is not an exception to the locus standi rule. Member does not have a locus standi where public interest is involved. That is my final answer. Member does not have a locus standi. Okay. Public interest is involved. Only central government has a locus standi. And that central government has been given power under 241(2) to make an application. So anyway, this whole thing is moot, because I will tell you, you take all the cases filed under oppression and mismanagement, you will never find one case where public interest is involved where the member is complaining. Invariably, it will be his interest is affected or a group interest is affected. Only then they will go. And invariably, most oppression cases are not against huge, well-known listed companies. They will be against closely held private and public companies where it will be a fight between brothers or it will be a fight between cousins, where one cousin will be controlling the company because his father is like Mahabharat, yeah. Mahabharat. Okay, everywhere you find Mahabharat. My father, your father. So the old man would have formed the group, would have done well. The two sons would have worked hard and they would have created further wealth. Then they would have had three children each, 2 daughters, 1 son, 2 sons, 1 daughter. All these cousins are there. Then fighting starts. Third generation, fighting starts. Who's my son was not given importance. And the brothers also, however much they want to be together, what they will do. Finally, when it comes to my blood, even if I am not shaking, my flesh will shake. So there is a proverb in Tamil Nadu. So even if I am not moved, my flesh is moved. So when somebody near and dear to me is Swajanapamanam, when my son is insulted, it is worse insult to me than even you insult me. Like that, all fight will start. And that's how you have fantastic opportunity for oppression and mismanagement. You have a fantastic opportunity for not chartered accountants, not even company secretaries. This is ripe area for lawyers to make a lot of money. Okay, where 2 families are fighting for corporate board. Fantastic. The lawyers will start sharpening their knife and be ready with their knife and fork for a fantastic meal at the table, because everybody will get fed. Right, left, and center bills will go from lawyer firm, just making a motion, making an adjournment motion, or one simple argument he will come and do, then he will go run away on behalf. Then one of the cousins will come in with his advocate and file a interlocutory petition. All sorts of super things will happen in there. Luckily, this is not High Court. Earlier, this power of giving relief for oppression and mismanagement was given to the High Court. Imagine how long it will take. That is why they gave it to the CLB. In the old law, this power was with the Company Law Board, which was the earlier version of NCLT. Now it is squarely with the tribunal. And I'll tell you one issue that came in those days. Now it has been solved. Now with the tribunal, it has been solved. So that's why tribunal is beautiful. In fact, if some of you have fallen in love with this law and you feel that you can make a career here, you can. Because chartered accountant can practice before the tribunal. You can appear before the tribunal. Only advocates can appear before courts. The magistrate courts and any court under the CPC, only advocates can represent. You can appear for your case, you can appear. But if you want somebody to represent you, that gentleman should be a member of the Bar Council. Only then he can appear on your behalf and argue the case. Okay. But in tribunal, you as a chartered accountant can appear. So if you have the ability and the skills which you can pick up easily by working under a suitable senior, you can go and you can argue and you can represent. And one of the ripe areas, where you can mint money would be oppression and mismanagement. Okay. Now, this is 241.2, right? Now we come to 241.3, which is a totally unconnected section. This is, central government has the power under 241.3 to initiate a case against managerial personnel. This power was earlier vested in they were in different sections. Now they have brought it together as part of the rationalization of the law. They have brought it together. So central government under 241.2 has the power to initiate in cases where there is a prejudice to public interest, independent of 1A and 1B, which is available only to members. Now 241.3, the central government can initiate a case. In the opinion of the central government, there exist circumstances suggesting that any person concerned in the conduct and management of the company or affairs of the company is or has been in connection therewith guilty of fraud, misfeasance. You remember what I said? Misfeasance is doing something, the intentions are good, but there is a violation of law. Intentions are good. Intention is not to defraud, but there is a violation of law. That is called misfeasance. Okay. So any person concerned in the conduct and management of the affairs of a company is or has been in connection therewith guilty of fraud, misfeasance, persistent negligence, or default in carrying out his obligations and functions under the law or of breach of trust. So he has been guilty of fraud, misfeasance, persistent negligence, or default. The business of a company is or has not been conducted and managed by such person in accordance with SBP or PCP, sound business principles or prudent commercial practices, right? Means, see, for example, there are one of the sound business principles, how to give credit. So the man may be giving credit foolishly, thereby incurring bad debts consistently. These are all examples, sound business principles, etc. A company is or has been conducted and managed by such person in a manner which is likely to cause or has caused serious injury or damage to the interest of the trade, industry, or business to which the company pertains. In B, fellow was only affecting this company. In C, he is affecting the trade itself. Okay. D, the business of the company is or has been conducted and managed by such person with intent to defraud its creditors. See, A is fraud, misfeasance, persistent negligence. Here, he is conducting this company with intent to defraud its creditors, members, or any other person or otherwise for a fraudulent or unlawful purpose, or in a manner prejudicial to public interest. So the idea of forming the company itself is to defraud. Maybe he's forming an NBFC, non-banking finance company. Idea is to accept deposits, run away. Something like that. Or, for example, we are going to see this type of thing going to happen. Bitcoins, forming a company, promoting Bitcoins, taking money from people, maybe giving some type of a return. Initially, they see some benefit. Suddenly, one fine morning, company is there, but the managing director is not there. The managerial persons are not there. That's all. So many people will lose. Then you get in a big report in the web, on the NDTV and all. What is the government doing? Nobody will ask whether these guys made any due diligence before investing their money. But of course, in that case, action can be taken against the managerial personnel, is the point. Okay. Now, 100% Bitcoin, I am using the word Bitcoin, sorry, that is not correct, because Bitcoin is one of the currencies. All these cryptocurrencies, digital currencies, digital assets, blah, 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 whatever bullshit, it is all going to be a big fraud and scam. And when the fraud and scam is exposed, at that time only people will realize. Now I'm telling, nobody will listen. I've been telling this on and off in various forums, right from public forums. I've been telling, don't invest, fraud, scam. Many engineers and techies and all, they laugh at me. They laugh and they say, even very close people to me who are techies, they call techies, IT fellows. They BE, computer science, they will be MCEL. They will be working in IT companies called techies. They would have invested in Bitcoin and made some money and all. They'll be telling, Mr. Srikanth, you're an old man. You don't understand all these things. It's all high tech. It's blockchain. Baba, blockchain, I know. Don't tell me blockchain. Blockchain is different. This is different. Cryptocurrency is different. Two different things altogether. Satoshi Nakamoto, when he defined Bitcoin, idea was that had nothing to do with blockchain. It was a way of rewarding the guys who mined. So they proved the hash for the blockchain. How to reward them? They won't do it. So they said, we'll create a Bitcoin. That Bitcoin will become. I'm personally, the Bitcoin story is the foundation on which the cryptocurrency is built. But on that flimsy foundation, they have built a huge superstructure that is tottering. And a day will come when it will fall. Okay, I don't know how many people will go with it. Why I'm taking up this point at all is because these are the companies that have to be targeted now under this section. Investigation should have started now. Who are you? What are you? What is your capital? How much are you collecting? What are you doing with that money? Who is your auditor? Everything should be now asked. And these fellows should be warned once and for all. You do any nonsense and I know about it, we will take action against the 241(3). This is the time to start action against these fellows. When things are still clear. When the whole thing bursts, what will happen? The money would be gone. See, nobody will be benefited. Suppose now you are able to show that these guys are doing something illegal. At least now you can take the money out and give it back to these poor bakras who gave it. But by the time the whole thing is there, thank you, Aniket ji, for agreeing with me. Okay, thank you. Though it is highly unwarranted and uncalled for a faculty of corporate laws to talk about cryptocurrency, I thought I will make your point. Check it out. See, at least humble request, discourage, you don't invest, discourage people from investing to the best of your abilities. That's all. You save them from the final death and destruction when that happens. Anyway, I'm giving this as one example where CG can take proactive action. Now they will keep quiet and watch. And then the finance ministry will come out and say, we are giving this digital act, taxation of digital asset, profit. What profit and digital asset? They are going to make huge losses. What you should do is, just like speculative gain cannot be set by that, only can be set off only against speculative loss can be set off against speculative gain. You have to bring a law like that. You say, whatever loss you incur here, you can only set it off against any income from cryptocurrency or a digital asset like that. You have to bring a law. Only then, otherwise, huge losses will be booked and claimed against normal income. Check it out. That's another problem. Anyway, the CG may initiate a case against such person and refer the same to the tribunal under 241(3) with a request that the tribunal may inquire into the case and record a decision as to whether or not such person is a fit and proper person to hold the office of director or any other office connected with the conduct and management of any company. That's all. Under 241(3), I am not taking any decision. I am central government. I am the protector of the public interest. I am merely initiating the case against this person and referring to the tribunal and saying, you are the tribunal. Call this fellow. See what he's doing. I will provide all the evidence. See it. Then you decide, is this fellow a fit and proper person to hold office? So, now the person against whom this case is referred to the tribunal shall be joined as a respondent to the application. Means he will also have the right to make his response. Agreed. In a democratic country, even the worst criminal should be given an opportunity to make his case. Okay? That is the essence of democracy. The majority shall have its way, minority shall have its say. The accused should be given an opportunity to make a statement. A reasonable opportunity shall be given to any person to prove his case, to prove his innocence. A reasonable opportunity shall be given. And if after that he is not able to satisfactorily prove, then the action will be taken. So the application under 241(3) will give a concise statement and materials, see, evidence for supporting their statement. See, I have made very blatant and bold statements about cryptocurrency, even at the cost of irritating and infuriating some of you. But evidence is there. Okay, I am slowly collecting evidence for no reason at all, except to say tomorrow when the whole scam bursts and it is reported to show that I told at that time itself. Okay, is the point. Every time I have told, nobody listened. I have told many times about for last 30 years, I have been giving suggestions like this. Whenever I gave that, they were laughing at me. Then when the loss came, sometimes they will say, Shrikant, you told at that time itself. Correct, but what was the use? None of you took heed. When in the Greek mythology, there is a lady called Cassandra. The curse on Cassandra was that she will predict the future, but nobody will believe her. See, when Paris walked into Troy, and she knew that he will seduce. I'm sorry, when Paris walked into Greece, and she knew that he will seduce Helen, and they will elope, and then the Iliad will come, and she knew that this whole thing will happen. So she prevented. She wanted Paris to prevent Paris from bringing Helen into Troy, but nobody listened to her. And later on, the whole Troy was burnt down, and the women of Troy were widowed. That is a curse of Cassandra, that whatever she says, nobody will believe at the time. When she says it, though it's the truth, they won't believe. So I think I also have a curse of Cassandra on me, that when I predict some doom, nobody will listen. Okay, anyway, let it be so. And let me see once more the crypto scam bursting, and at least in my heart, I will have the satisfaction. One more scam we predicted. Okay, what to do like that? So anyway, the application under section 241(3) shall contain a concise statement of such circumstances and materials as the central government may consider necessary, shall be signed and verified in the manner laid down in the Code of Civil Procedure and for the signature of verification. So the usual procedure. And at the conclusion of the hearing, the tribunal will record its decision. It's called a finding. The tribunal will give a finding, stating therein specifically as to whether or not the respondent is a fit and proper person. That's all. Tribunal's order will be a finding. They will find that he is not a fit and proper person. Okay. That's all. Yeah, beautiful. I'm so happy that, Pony is talking about The Big Shot. Wow, great movie. I loved it. And The Big Shot. Correct. Yeah, exactly. See, there, at least there is some amount of power available to the Securities Exchange Commission and FBI and all that. Here, nothing. They will sleep. And then suddenly they'll wake up and create a big fuss. And then they will make a law. After the whole thing has happened, beautifully they'll create a law which is of no use, because the purpose of the law has already gone. Now is when a law should be made to ban cryptocurrencies in India. Now is when the law should be given to ban them, to make them illegal. Now is the time to pass the law. Anyway. So, thanks for listening to this thing. 241.3 is a very interesting section. Now, what will happen after the finding is given, we will see. Okay, later. Now, once it is decided that he is not a fit and proper person, the central government will remove him. Do you remember? We will see that later. The central government will remove him. This is one of the grounds under which the central government can remove a director. That director who is removed by the central government cannot be reappointed by the company. One of the grounds by which central government can remove a director. Okay, now we come to possibly one of the most important sections in the Act. I mean, in this chapter. Can we say the most? Because the most important from the exam point of view. Why? Because this is a meaty section where we can ask you a numerical type of question problem where you'll have to apply the limits and all that. So frequently tested. Okay, frequently tested. So we have the minimum number of members having the right to apply under section 244. So there again, they classify as company having share capital, company not having share capital. So company having share capital, the minimum number is not less than 100 members of the company or not less than 1/10 of the total number of its members, whichever is less. 1/10 of the total number of its members, whichever is less. Or any member or members holding not less than 1/10 of the issued share capital of the company. I want you to just think, okay, why the law is using the word issued. Normally, wherever you found any limit based on capital, whether in an intermediate syllabus or in this syllabus, invariably, they were talking about paid up share capital. But for the first time, you're seeing a section prescribing a limit based on share capital and using the issued share capital. So, any member or members holding not less than 1/10 of the issued share capital of the company. Why? Why is it so? I want you to think and give me your answer. Then I will tell you my view, or maybe both of us will have the correct view. Think, why are they saying issued share capital? Why not paid up share capital? Usually they say paid up capital. Why here issued share capital? And even in the new law, intelligently, the MCA has retained issued share capital. They have not meddled with it because there is a valid reason why it is issued share capital. And I can also give you an example, a case study from my own example, from my own life. I told you, from almost as old as 1992, when I had the opportunity to audit a company which was the subject matter of Opression petition. And I was in the thick of it, right in the middle of the controversy, sitting there, okay, understanding. And that is how we learned. I learned the whole modus, how the tribunal, how the CL, in those days CLB and all that, how the CLB will do work and all that. Fantastic. So I'll share that story a little later, but before that, you think and tell me why issued capital and not paid up capital. So the applicant or applicants should have paid all calls and other sums due on his or their shares. So that they should not be in default. They should have paid all calls, etc. on their dues. Okay, somebody is going to ask me, what are those other sums? Gee, I don't know. Calls I understand. What other sums will be due on them? Mujhe nahi malum. I don't know. Okay, so don't ask me that question. Rather, you give me your view why it is issued share capital of the company. Okay. Now, suppose there are joint shareholders. Will they be taken as 2 members or 1 member? Normally, they are 2 members. Each is having a right of a member. But for the purpose of this section 244, joint shareholders shall be taken as a single member. Remember, joint shareholders shall be taken as 1 member. Okay. So this is for company having, so beautiful, issued share capital. Maybe calls are not made by company. No. See, uncalled capital is different. Here, it is going beyond that. See, issued capital, one above. Okay. Agreed. Your point is also correct. The capital is issued. Madam, please understand, issued in the hierarchy of capital, where will we get issued capital? Sorry, not madam. Mr. Jay. In the hierarchy of capital, where will you get your issued capital? See, you have authorized capital, then you have issued capital, then subscribed capital, then called up capital, finally paid up capital. Right? So this is issued capital, way up there, above subscribed capital. Please understand, the company has issued the shares, made a sort of announcement that these shares are available for, maybe the shares have been applied for, but not yet allotted. That category will also come in issued. That is the clue actually. See, in the hierarchy of capital, where will you get issued? Above subscribed. When it becomes subscribed, only when the allotment is over, it becomes subscribed. Here is a case where application has been made, money is collected, the shares have been issued, but not allotted. That category is now given an opportunity to make an application. Why? I have seen a practical example. That's why I know the reason. I can share with you and you can ask me, is it correct? Practically, I have seen. Now, company not having share capital, not less than 1/5 of the total number of its members. That is fairly simple. Now, suppose the minimum number is not available, but it's a genuine case, but I'm not able to get the minimum number. Remember, now there is a power available. The tribunal may, on an application made to it in this behalf, waive all or any of the requirements as to minimum number. So even if the minimum number is not there, you can apply to the tribunal, get a waiver, and the lesser number can apply under section 241. This is something very important because in the exam, if they ask you a question on advise the members, and if your conclusion is that the minimum number is not there, you need not say members are not entitled to apply. You can say the minimum number is not there, therefore the members are not entitled to apply, but they can make an application to the tribunal for waiver of the requirement as to minimum number and apply with the permission of the tribunal. So this is something you might want to remember. This is something very peculiarly now. Earlier, of course, what could happen was they could go to the central government and central government will make. Under this power, 241(2), they will go. Equivalent of 241(2). But now the members themselves can go, even if they are less than the minimum. So again, you are confusing between issued and paid up capital. See, paid up and called up capital area only you are fighting. Go up, go up, go up. Above subscribed. Issued is above subscribed there. That is why they are using issued is very powerful term. You are again and again looking at people. And remember, if a member has not paid the calls, he is not entitled to apply. If any amount is due from him, he is not entitled to apply. So those who don't pay till now, yeah, they are a member, but they cannot apply. Sorry. Of course, getting the logic is very difficult, but if you can think. Okay, now the time for my clock is 7:45 almost. Right, my dear friends, 7:45 almost. Therefore, I thought it will be a good, because we've been going a little heavy and it's been a little thing. Let's have a break. Okay, till 8 o'clock. 15 minutes. Go have your cup of chai. Relax. Apply your mind on why issued capital. We will come again and we will start our deliberations on oppression and mismanagement. Okay. Welcome back from that, I hope, well-deserved tea break. Let us see if anybody has given any suggestions as to why it is issued capital. Yeah, Jay gives us something. Maybe company is not allotting shares with wrong intention to a particular group, like in case of NDTV and Adani. That is why issued share capital is used to give such prospective shareholders. Wow. Powers to prevent oppression. Beautiful, sir. Correct. Hit the nail. Fantastic, Mr. Srivastava. I'm so happy. So let's see what Bonnie has to say. You're right. Your example of NDTV is also beautiful, and Adani and all. Yeah, and I have an earlier case itself for this. Sir, issued share capital is larger than paid up share capital. It's the one that has chance of becoming the future paid up capital. Only 1/10 of the issued capital would be, yeah, that is there. But see, they are saying issued 1/10 of the issued capital. Sometimes during the issue of shares, some mismanagement. Exactly. That is also correct. May happen if you use the term paid up share capital. If the members in issuing stage are affected, they are left out. Wow, I love this. You're really brilliant. That is exactly the point. So even the members who are applying for share capital may also have the right to apply. Fantastic. I'm so happy. So happy that this is a very good batch. I'm so happy. This much you are able to write. I tell you, you guys are all too good. Yeah, this is exactly the point. See, if this is said, if this is prescribed as paid up capital, then only those people for whom the shares have been allotted can make an application. Whereas the oppression may be not allotting the share. Yeah. This guy takes money, gives an application. I fill up the application. He sends a prospectus. I see the prospectus. Based on that, I give the application to this bugger. He takes it. He takes my money. And then he doesn't allot the share. Hey, that is my complaint. My complaint is that, what is the act of oppression being complained of? Non-allotment of shares. Okay. And then in addition to that, he's taking that money, misusing it, and then whatever. That is why they say issued share capital. Okay. And as Bonnie rightly points out, issued capital will be larger than paid up. But that is not the reason. See, it will be larger than paid up. That is something that you might want to see. In which case, 1/10 of that number may be larger. That you have to be a little careful. In fact, my friend Mr. Srivastava gives the examples of NDTV, Adani and all. Those days, I had a very, very peculiar case. I was not representing them. I was the auditor for the company. In fact, the company, if I try to hide it also, you'll be able to easily find out. But in fact, in one of my sessions, one of the participants immediately Googled and got that case law from the Tribunal archive. He got it out. And which means what do you call it? One second. Sorry. The company I'm talking about was the first company to, was the first private air carrier of passengers. First private, they got the first license from the DGCA when the liberalization started in 1990s. The Civil Aviation Ministry, they liberalized this aviation, civil aviation. So this is domestic, in addition to the existing government company, which you all know, which is now taken over by Tata. They said private operators can also come. And the first license, I should say, was issued to this company. And this company was formed. Very much I was involved in that process. I went on to become the auditor of that company and all that. And I was auditing it. Okay, that company founder was there. He promoted it. He invested, if I remember right, at the time, something like 1 crore in those days. Okay. But he needed more money. So what he did was he went all over the world, Kuwait, Bahrain and all, and he gave prospectus. He gave an application form. Everywhere they violated every law known to Indian government, they violated. Okay, they discovered new laws to violate, and they violated that. like that. They found out whether any more laws are there. Can I violate it? And they violated. FEMA, those days, FERA, everything was violated. And so ED was on top. Everybody came. That came later. Initial stages, it was all big celebration and went around collecting money. One shareholder, for the sake of, I think we'll say TJ. We'll call him TJ. Okay, TJ. This TJ invested for 3.5, no more than almost 4 crores in that company. Now, he also applied for those shares, but the shares were not allotted. Remember, this is a superb example of two things. One, if you take the issued capital, TJ is the majority shareholder. Also, one of the reasons for oppression is shares have not been allotted, but he is having proof. Money has gone from his account. Checks have been issued, credited in the company's account. Proof is there that he gave the money. Application form is there where he has signed, accepted, acknowledged by the company. But allotment is not done. That is the ground. Therefore, the majority holder of the issued capital applied for relief to the CLB for oppression and mismanagement. And CLB heard the matter and they gave some relief, but nothing could be done. By then, what had happened was the money had been used up, rightly or wrongly and all. My role was more of an auditor, and at one stage, the company's accounts were a mess, and the tribunal wanted me to give a report. So tribunal said the auditor is hereby directed to audit and give a report. I said, how can I give a report when nothing? So the accounts were created out of existing records. And finally, I said, I will give a disclaimer. No, you can't give a disclaimer. You have to give a audit report. I said, if I give an audit report, it will be qualified audit. Okay, you give a qualified. Then I gave a qualified audit report. Everything qualified. Caro completely, almost, at that time, 19 or so. Almost 16 were qualified. So, I can't protect myself, boss. This is going to the tribunal. And tomorrow, anybody can take action. So, but TJ was begging me. Literally, TJ was begging me because he was saying, Srikanth, somehow the case has to continue. Without accounts, the tribunal is not willing to continue. Do something. They have given control of this company to me. But now they are saying submit the accounts. I said, sir, how can we submit those? At that time, the accounts were not there. Nothing is there. Bank records, nothing. So finally, they created the accounts out of whatever records were available. We audited it. Qualify. Everything was qualified. Including 227, at that time 227, 1 year, that inquiry has to be made now. There also I made a qualification. And I gave. At such an early stage of my career, it was a huge experience for me. It also helped me to understand that how complicated it is to take up audits and all. It's not easy. That I learned it the hard way. And I realized that, it's very difficult to do this. Okay. So for your information. So that is why it is etched in my memory, because TJ was holding the issued capital, but he was not having paid up because shares have not been allotted. That was the first ground. So the first order that the tribunal said was allot the shares. The shares are allotted. Then they came and produced it. Then the next step came. Then management and control of the company was given to TJ. Then board was there. Then the directors were appointed on the board to effectively. Everything was done. And I was, as auditor, I was told to attend the board meeting. I gave my report and my view. And then that's when this whole thing happened. Auditing and all. 3 years audit was done in 6 months. We did it. Completely qualified report was given. Thereafter, I don't know what happened to that company. Honestly, I don't know. I'm seriously not aware of what happened to that. We parted ways at that point in time. And I went on to audit better and better companies. And this company went, I don't know where. But that 1.5 years of my life at an early stage in my life was a very, very rich experience for me. I was able to see how it happens. Anyway, so the issued, subscribed and paid up capital of ABC Nidhi Limited is 10 lakhs, consisting of 90,000 equity shares of rupees 10 each, fully paid up, and 10,000 preference shares of rupees 10 each, fully paid up. Out of the members of the company, 400 members holding 1 preference share each, and 50 members holding 500 equity shares applied for relief under Section 241 of the Companies Act 2013. As on the date of petition, the company had 600 equity shareholders and 5,000 preference shareholders. So, 400 members holding one preference share each and 50 members holding 500 equity shares applied for relief. Okay. Now, whether the petition is maintainable. Will your answer be different if preference shareholders have subsequently withdrawn their consent? So, from this example, I am able to learn one thing. Member includes the holders of preference share also. All are members. Okay. So, this is a question on requisite number for making application under Section 241 read with Section 244. As the total number of members is 450, the criterion of not less than 100 members prescribed by 244 is satisfied. So, what is the criteria? 100 members. 100 members or 1/10 of the total number of members, whichever is less. Whichever is less. Or any member of members holding not less than 1/10. So, total number of members of the company, okay, is 600 plus 5,000, 6,500, 5,600. So, 1/10 is 560, whereas total number of members is 450. But whichever is less, so 100 is less. So, if it is more than 100, it is enough. So, total number applying is 450. Therefore, it is not less than 100, accept. Therefore, the application is valid. The fact that the preference shareholders have withdrawn their consent subsequently would not affect the maintainability of the petition. The withdrawal of consent by any shareholder during the course of proceedings shall not affect the maintainability of the petition. So, this topic is one thing where you might want to remember case laws. So, this is one case law, Rajamundry Electric Corporation versus Nageshwar Rao. So, for this purpose. Okay, beautiful. ABC Private Limited is a company in which there are 8 shareholders. Can a member holding not less than 1/10 of the share capital of the company, can a single member, one member holding less than 1/10 of the share capital of the company apply to the tribunal for relief against oppression and mismanagement? So, the single member is not holding 1/10 of the equity issued share capital. Though the word share capital is used, we shall presume it is issued share capital. See, in most cases, issued, subscribed, and paid up will be the same. It's only in these extraordinary cases where the issued may not be allotted, therefore subscribed will be lower than issued. Only in rare cases, right? So, he is not holding 1/10 of the share capital. Single member, can he apply? So, the point of question is, can a single member holding less than 1/10 apply when there are 8 shareholders? Okay. For relief against oppression mismanagement. The issued and paid up capital is 5 crore, consisting of sorry, this is another question. Okay. Now, the issued and paid up capital of MNC Limited is 5 crores, consisting of 5 lakh equity shares of rupees 100 each. Let us come to this a little later. Let us take up ABC Private Limited case. 8 members. Am I correct? Yeah. 8 members. 1 member is applying. Now, what is 1/10 of 8? 8 by 10. 0.8. Now, 0.8 you cannot have here. You cannot have 0.8 member. So, 1 member can apply. In this case, there are 8 shareholders, 1 member can apply. 0.8, na? So, 1 member can apply. If 1 member would apply, na? Because it's 1/10 is 0.8. 1 member is more than that. Now, 1 member is better than 0.8 member, right? So, 1 member can make an application, even though he is not holding 1/10 of the share capital of the company. Right? I hope you understood the logic. So, just give me 1 minute. Somebody is trying to contact me. I have to inform them. Just give me 1 minute. Sorry. In the meantime, you can read the next problem. So the issued and paid up capital of MNC Limited is 5 crores, consisting of 5 lakh equity shares. Okay, let me see. Shailendra Singh says 1/8, 12.5. What is that? Of member. 1/8. My limited understanding is not able to, my limited brain is not able to understand this cryptic comment, Mr. Shailendra Singh. Can you elaborate a bit? I mean, I think you got the point, right? 1/8 of 1/10 of 8. 1/10 of 8. So I don't know what you mean by 1/8. 1/10 of 8 is 0.8. So 1/10 into 8 is 0.8. 0.8 you can't have. So 1. So one member can make an application, even though he is not holding 1/10 of the issued capital. Right. The issued and paid up capital of MNC Limited is 5 crores, consisting of 5 lakh equity shares of rupees 100 each. Right. The company has 500 members. A petition was submitted before the tribunal, signed by 80 members holding 10,000 equity shares of the company. Okay. So the company has 500 members. For the purpose of relief, examine the provisions of the Companies Act and decide whether the said petition is maintainable. Also explain the impact on the maintainability if subsequently 40 members who had signed the petition withdrew their consent. So there are 3 criteria, right? So you have first criteria, 100 members. This is not 100. Or 1/10 of the total number of members, whichever is less. So 1/10 of the total number of members is 1/10 of 500, gives me 50, which is less. 50 is less. So 50 will be taken. So 80 is more than 50. Straight away satisfied. You need not go into the issued capital at all. Even then, if you want to do that, these 80 members are holding 10,000 equity shares. Okay, each equity share is 100. So 10 lakhs. Okay, so 5 crores. This is 10 lakhs. 1/10 of the issued capital, 50 lakhs. Whereas this is only 10 lakhs. So issued, that criteria is not satisfied. But 50 members is the 1/10 of total number of members, whereas you are 80. So at the time of making the application, 1/10 of the total number of members is there. Therefore, application is maintainable. Petition is maintainable. Subsequent withdrawal will not affect. We already saw that in Rajahmundry Electric Corporation case. Okay. Good. Now, a group of shareholders consisting of 25 members decides to file a petition before the company law board for relief against oppression and mismanagement by the board of directors of Messrs. Fly-by-night operators. The company has a total of 300 members, and the group of 25 members holds 1/10 of the total paid up capital, accounting for 1/15 of the issued share capital. Wow. 1/15. So 15 is greater than 10. Na? The main grievance of the group is that, let's not bother about that. First question regarding the success. First of all, maintainability, let us see. So company has 300 members. 1/10 is 30. 25 members, not 100, not 30. It is less than 30, which is 1/10 of the total members. So they are not there. They hold 1/10 of the total paid up capital, but which is 1/15 of the issued share capital. Now, what to do? So 1/15 is less now. You need 1/10 of the issued capital, whereas they are holding only 1/15 of the issued capital, right? So none of the criteria are satisfied, right? So they are not statutorily eligible to make an application. But you already know now, under 254, Tribunal can authorize them to make the application, provided it is satisfied that circumstances exist which make it just and equitable so to do. So the members are advised to approach the Tribunal in this regard, because we can't decide for the tribunal and say, tribunal, you should give. That tribunal may not agree. So, but we can see what you are required to do here is to advise. Please understand, advise the group. So advise them to go and see if it can be worked. First of all, you are not eligible. But if you still want to apply, we will make an application to the tribunal. Let us see what the tribunal decides. That is the way you have to go. Now, one of the complaints now, okay, the grievances due to mismanagement, the company is incurring losses and the company has not declared any dividends, even when profits are available in the past years for declaration of dividend. Very contradictory application. First of all, they are saying loss. Okay. But they are saying in the past years there was profit, give us dividend. Both these conditions shareholders cannot claim. It is the board of directors' discretion to give dividend. 1, 2, merely incurring losses is not a ground for mismanagement. Merely because the company is incurring losses, you cannot say mismanagement. You should prove some malafide intentions, some siphoning of funds, something prejudicial to the interest of the company. If merely incurring losses is a criteria, then many managements are guilty of mismanagement. Okay, so merely incurring losses, there should be some malafide intention, siphoning of funds, manifest injustice. Then only you can give relief. So even if these fellows are successful in making the application, tribunal may not help them much. Is the conclusion we come to. Now, going on with some more problems. A group of shareholders of Badwill Machineries Limited filed an application before the Company Law Board, now NCLT. In those days, Company Law Board. This is a question taken from an older exam paper, alleging various acts of fraud and mismanagement by Mr. Big Fish, the MD or his associates. During the course of hearing before the CLB, the authorized representative of the said company contended that the alleged transactions had taken place several years ago, and the company has already removed the managing director who was responsible for such transactions. But the applicants have stated that though these acts were done in the past, and the managing director will removed, the company is still controlled by him through people who are in league with him and who are his henchmen. Henchmen means people who listen to him and do what he says. Okay, chamchas, they are the people who are running. So this is a very, very fact-oriented case. Bottom line, the answer is, in those days, oppression, they said, should be present and continuous, are being conducted. Whereas here it is an isolated act. Whereas today, the law has been amended. Please keep in mind, if this application were made today, past acts are also ground. Even past acts have been conducted. So that could be taken. Okay. Now, so we have understood up to now what is oppression, what is mismanagement, how an application is made to the tribunal, how central government can refer a matter to the tribunal for finding whether a person is a fit and proper person to be a managerial personnel, and also the requisite number. Please be thorough with the requisite number. It is very, very important. So 241 over, but very lengthy section and very important section. One of you can say there is a essence section. So we have finished 241 and 244. We have finished 241 and 244. Why? Because without knowing 244, how will you understand? How will you make an application? You should know the requisite number. Therefore, 244 was taught. That is why, I will not go in the sequence of sections. I will go in the sequence of logic. So 244 should be known to you. Only then you can understand 241. Now, 242 now, which talks about the powers of the tribunal. Another very important section. Question by Bonnie Jose. Can one file such application against the removed director for past oppression? Today, you can file an application for past oppression. Okay, 1. 2, you are not filing it against anybody. Understand? You are merely petitioners. You are going before the tribunal. That director may be included as a respondent if you so desire. Right? So, do you notice one thing? This goes exactly against the grain of Foss versus Harbottle. One of the exceptions of Foss versus Harbottle. Yeah, you can file against removed director if he is still continuing controlling and he is in league. Because to answer your question from a different angle, if you are studied investigation, you will understand central government has the power to determine the true ownership of a company. Okay. And they can say who is the real person controlling the company. And that person can be called a deemed director. A person who's in according to whose instruction and direction the board of directors of a company are accustomed to act. So then this person can also be involved and we can fight. Because think about it. You remove him thinking that he will not interfere. Man is still interfering by using tentacles, like an octopus. He is sitting somewhere and using his henchmen to do. So yes, why not? You can. Finally, who will decide? Tribunal will decide whether they are going to allow or not. Okay. You and I cannot sit here and do. Go and test yourself in the tribunal, but yeah, if there is a manifest fraud, injustice, the tribunal will interfere. But before doing that, sometimes they might ask the central government to investigate. I don't know if you've studied investigation provisions. So there you will find one of the grounds when the central government shall conduct an investigation is when directed by the tribunal. So this would be one way where the tribunal, they will trigger an investigation into the affairs of the company. Then the report will come to the tribunal. Based on that, the tribunal can take action. One of the reliefs that you can get, see, based on the report of the inspector conducting the investigation, one of the reliefs or one of the course of action is the tribunal can wind up the company, or the tribunal can give relief under oppression and mismanagement. So these are all linked provisions, actually. Okay, it can direct. So like that, there are many things. So can do. Today, the central government is having a lot of clout and power, and tribunal has a lot of clout and power. They can call. Why not? But see, Mr. Bonnie Jose, if you are an advocate, then you will argue like this only. He is a past director, which is what they have tried to argue now. They are trying to argue that only, that this guy is a past director, not having any role in it. But you have to disprove it by giving evidence that though he is out, why is he writing a letter? Why is his mail coming here? Why is he being marked? Like that, you have to produce evidence. Okay, 242, powers of tribunal. On any application made under section 241, the tribunal may be of the opinion that the company's affairs have been, they are now forming the opinion, have been or are being conducted in a manner prejudicial to public interest, or prejudicial or oppressive of any members, or prejudicial to the interest of the company. Okay. So they are forming opinion. First of all, the tribunal says, yeah, it's prejudicial to public interest, prejudicial or oppressive to any member or members, prejudicial to the interest of the company, and that to wind up the company would unfairly prejudice such member or members. But otherwise, the facts would justify the making of a winding up order on the grounds that it is just inequitable that the company should be wound up. That is, the oppression is of such a degree that it is better that the company be wound up. But to wind up the company would unfairly prejudice such member or members. Therefore, with a view to bringing to an end the matters complained of, the tribunal shall pass such orders as it thinks fit. Beautiful section. Beautiful thought. See, there is oppression. It is of such a degree that nothing can be done. You remember that French company? You remember this case? Indo-French. There's a deadlock. So that's why I said I'll come back here. So this is a classic example where under 242, the tribunal can form an opinion that it is better that the company be wound up. But if it is wound up, the affected party will be the applicant. Therefore, they will say, please, let's give relief. So they will give options. You buy, let him buy, you take over. Like that, they will start giving options. to bring to an end the matters complained of, the tribunal is empowered to pass such orders as it thinks fit. Right? Now, so this is what are the orders which can be passed? But one thing, you see, for mismanagement, I don't see any power here. Where there's a material change, etc., I don't really see any power. This is mainly relief for oppression. Where there's oppression, where is relief for mismanagement? We don't know. Okay. Anyway, we shall presume that when the tribunal is apprised of either 241 1A or B, the powers which are given under 242 are common. So these powers can be applied in both the cases, is what we would say. Okay. See, if you read section 397, 398, 399 on those days, it will be beautiful, almost like poetry. It will be beautiful. Wish these fellows have not touched it, except to make small changes like have been and all that. I have no problem with it. But otherwise, I wish they had not meddled with that format. Okay, they have not meddled with that format. I even give them 241-2, but I wish they had not meddled with the basic format of 397 and 398, which was well drafted by the British. So we are, boss, if you are drafting in Hindi, it is your mother tongue, yeah. It will be fantastic because it is your mother tongue. This was drafted by a Britisher in his mother tongue. Therefore, obviously, it will be superior. So that he has done a better job than you. And we should not try to interfere in those cases. But that's what they have done and made as usual, they've sort of made a mess of it in a way. But it's okay. We can always read meaning into whatever nonsense they've done and said, okay, 241(1)B also there is a provision, the powers are common, 242. Because they say on any application made under 241, right? But this is the old law. This was mainly a power given to the tribunal under 398. See, what happened was your 1A and 1B were not separated from 242 this way. 398 had its own relief provision. 397 had its own relief provision. So you simply had to read that. Whereas now they've separated, then brought it here to 242. Powers of. Anyway. Point is, the tribunal should be satisfied that the affairs of the company's affairs have been or are being conducted in a manner which would justify winding up. But to wind up the company would unfairly prejudice the applicants. Therefore, so the point here is the applicants should show that the oppression is of such a degree as to warrant winding up. But the tribunal should then say, hey, if I wind up, what will happen? The guy who, you know what would have happened? Take, for example, this case of that air traffic company, the first passenger carrying company there. Already the funds have been siphoned out by the promoter. Now the guy who invested, his money is also gone. Now the company is a shell. Suppose the tribunal says this oppression is such a degree, it is better to wind up. And then they go on and wind up the company. Who will be affected? Because there's nothing in that shell. Winding up will result in zilch. So, to protect the applicant, they will say, look here, what is your complaint? Money has gone out of the company. Who has taken it? We will identify. We will make him refund that money and give it back. That is the relief to bring to an end the matters complained of. So, that power has been given to the tribunal in this section. Now, when you are going on to winding up, you will find that there is a link with this section. As you can see, winding up is mentioned here. Later on, when you go for winding up, you will find one of the grounds on which a company can be compulsorily wound up is that on the grounds that it is just and equitable so to do. It is one of the grounds for compulsory winding up. Now, in that topic, there is a case law. Ibrahim versus Westborn Art Gallery Limited. Ibrahim versus Westborn Art Galleries Limited in a British case. That's a nice case. If you listen to the story, you will understand Opression better. What happened? There were two gentlemen, Ibrahim and Nasser. Both of them were engaged in antique dealers. They were sourcing antiques from all over the world, especially the Far East, and they were selling them in their showroom in London, in Westborn. So it was called Westborn Art Galleries. where they were doing this, well, profitable business, doing very well. Ibrahim and Nasser were good friends. Things were fine. Okay. So on and so forth. One fine morning, for Ibrahim, you know what, in India we have this Saturn, the planet Saturn, you know, if it is up, it is certain malefic positions, for 7.5 years it will give trouble. So this fellow Ibrahim got 7.5 years Saturn when, you know, when they admitted Nasser's son as one of the shareholders, NS. So because Ibrahim and Nasser were good friends, what they did, see, they were 50-50 partners. You know what Ibrahim and Nasser did? They each gave 5% to Nasser's son. And Nasser's son NS came into the business. So E and N admitted NS by giving 5% each. Now what has happened? Subtle change in the equation. Do you see that? Ibrahim is now 45. Nasser is also 45. But Nasser's son is 10. So together Nasser and son control 55 as against Ibrahim 45. Now the father and son together, I gave one example, no, Jay, about the money having been siphoned, the shell is only left. Now to wind up the company, what will anybody get? Nothing. So we have to keep the company alive, bring the money back and refund it to these people or give relief. And the affected directors also should be, otherwise those directors will go scot-free on winding up. They'll simply wash their hands, give it to the liquidator and go. They will take some till and some water and put it there, tarpanam and give and go. That's all, matter over. With that, everything, my duty is over, like that, they will say, and they will go off. Okay. Now, that is why they, in order to, you know, thing. Now, sorry, I'm very, very sorry. So this one, coming back to our friends, Ibrahim and Nasser, okay, some questions are coming. Let me, we'll take it up. So before that, let me start this story of Ibrahim and Nasser. So what happened now? Nasser's son has come into the business. Now, so father and son together created so much problem for Ibrahim. Ibrahim became so frustrated. Think about it. Two people all are together, very good friends. Suddenly, they won't talk. Whenever a decision is taken, Ibrahim and Nasser and Nasser's son will say no, or they will instruct the employees to behave in a rude manner. If such things all, I can tell you, there are many. I've seen cases like that, where the employees will not know what to do. They will side with the person who is helping them. So the other man, they will insult. Such examples are there, where one director will come, instruct the person and go. The other director will come, give another instruction. Or one director will come and say, whatever that fellow says, don't listen to him, you listen to me, like that. These are all. So this happens. So Ibrahim got so frustrated. So the fellow made an application to the court in England for relief from oppression. Are you able to understand? The application, you will see this case line winding up, but the application made was for oppression. What Ibrahim wanted was relief from oppression. But during the course of the hearing, in that case, the court came to the conclusion that the oppression is of such a degree that it is better to wind up. And then they went on to wind up because there was no prejudice to Ibrahim. The company had sufficient assets. All that was needed was wind up the company, sell the assets or distribute the assets, close the business and go. Ibrahim goes this side, Nasser and son go that side. Each conducts their own businesses. Simple. Such a solution could work, then winding up will be a good idea. But if no asset is there, Nasser and Nasser's son have siphoned everything, then to wind up would unfairly prejudice Ibrahim. Therefore, they would have gone for oppression relief. But in that case, there were sufficient assets. So they wound up the company. Are you able to understand? Depends on the situation, etc., etc. Good. Now, 100 members include share market shareholders also. What do you mean by share market shareholders? I'm not able to understand the word. Pradeep ji, you will have to explain to me what you mean by share market shareholders. What do you mean by that? They are also members only. Sir, if you have purchased a share, for example, if you are buying a share in the market, okay, how it will happen? That the person who sells it to you will give a DP advice. Correct? That DP, NSPL or CDSL, that the seller DP will immediately transfer the share to your DP account. Then your DP, whoever it is, NSDL or CDSL, will inform the company. This whole thing will taken within the end of the week. And by the end of the week, the end of the day, the end of the day, the company will receive they will download the data from the NSDL and CDSL database. So that by the end of the day, your name will be entered in the register of members as a member. Maximum will take 48 hours or 72 hours. You will become the owner of one of the members of the company until you sell it. When you will cease to be, and the new person will come. So I really don't understand what you mean by share market shareholders. There is nothing special category called share market shareholders. They are also members. Okay. Who is a member? Definition of member: every person who applies in writing and whose name is entered in the register of members or updated in the records of a depository. So long as they satisfy that criteria, they are members only. Even if he is purchased in the share market, he is member only. So, Pradeep ji, I need some clarification on this. I hope I have clarified your question. So, if you to answer your question, yes, they will include. But to go beyond that, to give you some more inputs, there is nothing called a share market shareholder. That fellow is also a member because his name is updated in the records of a depository. That is why definition of member itself has been clearly given in the Act. Sir, have you got it? Please confirm that you have got my point. That gives me some. Yeah, I got your point. Share purchase. I explained the process now. Ultimately, he will become a member only. So the word member is clearly defined in the Act, sir. Every person who applies in writing to become a member and whose name is entered in the records of in the register of members or updated in the records of a depository. Please check up the definition of member under the Companies Act. Okay. Got it? Yeah, share purchase from secondary market in no way it's different from any other method of acquisition. So, got it, I hope. If his name is updated in the register of members or in the records of a depository, automatically he is a member. Okay. That's all. So, I hope you got it. And again, being a purist in the use of language, I insist that, use the words very carefully. Every word in law is defined. And we should not, when a word is there, don't use another word. When a word member is there, very clearly defined, don't use the word share market shareholders, which is vague. Share market shareholder is also a member. Okay. Fantastic. Now, we now go to the powers of the tribunal. Powers of the tribunal, which include, first of all, regulation of conduct of affairs of the company in future. So the tribunal may, on the application of any party to the proceeding, make any interim order which it thinks fit for regulating the conduct of the company's affairs upon such terms and conditions as it may think just and equitable. I always give an example like this only. Suppose in the nursery, LKG, UKG, two children are fighting. The teacher has to bring to an end the matters complained of. One boy will say, he is hitting me. Then I will say, no, he is poking me in the back. He only started, blah, blah, blah. Boss, first of all, both of you go to separate sides. You sit in this side, you sit in that side. So, regulation of the conduct of affairs. This is your power, that is your power. Do what? So all the rules and regulations will be given. So, no, he is interfering with me. So, what is your condition? Sir, I'm handling marketing. He is handling purchase. So, clarify. Okay, here. This is how the rules will be. They can give such conditions and ask them to accept it and move on. See, today I find with third generation businesses, family businesses, one of the important problems I'm facing is, or rather one of the important type of situations I get is disputes, intra-owner disputes, especially in family-owned businesses, more than anywhere else, where family members want to split or they are not happy. So they come to, the first point of contact is their auditor. So they come to the auditor. You have to be very careful. You cannot side with anybody. All are equally important. That is why you and I, as members of the Institute of Chartered Accountants of India, we have a great opportunity to become mediators. mediation, because in mediation you have a lot of liberty. Unlike arbitration, where it's strictly controlled by the Arbitration Conciliation Act, mediation you can sort of give a lot of support to the people. You can even make them come to an agreement and get into a mediation agreement. And even if they have gone to the court, the court can direct for mediation. And once the mediation agreement is made, the withdrawal will be there and they can go on with the business. So regulation of conduct of the affairs of the company in future. So very, very important thing. First step, try to bring to an end. See, why go for fight? Why go for a stop? Regulate. First step. Not working. It is not possible, sir. If I see his face, I get angry. I've heard this in Tamil. Even seeing his face, I'm getting angry, sir. I can't. It's impossible for me, sir. I cannot do anything. Sorry, what to do? Then call them. Who wants to continue with the company? A says, I want to. B says, I am not interested. Chalo. Then Mr. A, buy his shares. Purchase the shares or interest of the company by other members thereof. So you call A, you want to continue. B, you don't want to continue. You want to go. You pay him, value the business. Well, registered valuer is there. We'll do. You don't agree, you get your own valuer. Bring the valuation report to us. We will put an independent valuer. Finally, we'll come to a conclusion, pass an order. At that value, you purchase. No, I can't buy. Like, okay. Does the company have the money? Yeah, company has. Then let the company buy. But when the company buys, what will happen? When the company purchases shares of any member, first of all, there's a prohibition. You studied this in intermediate. Company cannot purchase. Actually, there's not a prohibition. It's a conditional prohibition. It says purchase by a company of its own shares cannot be done unless the consequent reduction in capital is confirmed by the tribunal. Now, who is directing the purchase of the shares of any member? It is the company. The tribunal itself is telling you purchase. So the tribunal, having told, that can direct. They can direct. The consequent reduction in capital also can be confirmed. So that is why they say that tribunal. See, you tell two groups are there. One group, both are at loggerhead. They can't stand. So they say, call them and ask them, you want to go, you want to go. Or you want to go, continue, you want to go. Pay him, take the share, close it. No, sir, I can't do, I don't have money. Okay, company has money, purchase. Then if the company purchases its own shares, then the consequent reduction of share capital here, we are confirming. Who is the authority to confirm? Tribunal. We will confirm it, take it. So that power is also given to the tribunal under this section. The power to confirm the consequent reduction of capital. Okay. So the tribunal can pass orders for the consequent reduction of capital also, because see, that's a very long-winded provision. Whereas here, it is all before the tribunal. The tribunal itself will pass the right for the consequent reduction of capital, because they would see, while doing so, the tribunal should be very careful. They should take into account the interest of everybody, because creditor also sitting here. If any major creditor is there, that will also should be given an opportunity to object or so. In as much as he cannot come and say ownership should not be changed and all. That is not for him. He can say my rights are prejudiced. So tell me how your rights are prejudiced. Because of the reduction, we will make it all right later. Because what will happen is, when there is a purchase of its shares by the company, money will go out of the company to one group. And to that extent, the capital will come down. So the debt to equity ratio may be skewed now. It almost amounts to buyback now. So that skewing could prejudice the rights of a creditor. Therefore, that creditor should be given an opportunity to object. And if his objection is fair, then he should be settled also. So you settle him, you settle these fellows, take the company and run, do whatever you want with it, like that. I'm only giving you these practical inputs to help you understand that what you're studying in the pages of your institute material is a complex human drama going on in the tribunal. You see, to understand. Okay, it is people's life and bread and butter. Their entire lives, whole Their life and soul has been put in this company and they are fighting to retain it. That type of emotional connects will be there for people, so on and so forth. 35 years, a chartered accountant in practice, I've seen so many emotional connects. People have kind of held on. They don't want to let go of the company. Fighting has happened. I've seen brother fighting with brother, father fighting with son. Recently, one father came to me, 92-year-old man. He comes to me and he says, I want you to file a criminal case against my son for oppression. Son is oppressing the father. He says, my son is oppressing me. Please make an investigation and kindly file a petition against my son for oppression. Father is telling against the son. I said, again, I tried to convince him, sir, it's your own son. Why don't you come for mediation? Sit and talk. Let's have a bite. You talk, he talks. Let's solve it. It's not going to, no. Whatever happens, I do something. But that is the end of it. And, I did not encourage it because I'm not very comfortable with it. Father and son. Why? I quietly went out of it. It's easy to create problem there and earn money. But that's not the way money should be earned. Okay. Restriction on transfer or allotment. Restriction on the transfer or allotment of the shares of the company. See, what could happen is the mismanaging group could be quietly transferring the shares and trying to run away. Or they might be allotting more shares to themselves to further dilute the minority. Either way, the relief can be no transfer will be allowed. Till such time this is decided, matter is completed, this case is closed, no transfer. Okay. And if there is any agreement between the company and the MD, that can be terminated, set aside, or modified. This you actually saw when we spoke about removal of MD, where the tribunal has the power to decide whether the contract is so that if the contract is not valid, they can terminate it, thereby removing the MD. Any other director or manager upon such terms and conditions as may be, in the opinion of the tribunal, be just and equitable in the circumstances of the case. So, termination, setting aside, or modification of any agreement between MD, director, or manager. Any other director or manager. Okay. Termination of contract would mean the person will no longer be an MD, but he will continue to be a director. So what we are doing here is only terminating the contract, agreement between them. See, idea is that that agreement may be prejudicial to the interest of the company. In those cases, they are terminating it, setting aside or modification. Termination of agreement with any other person. The termination, setting aside or modification of any agreement between the company and any person other than those referred to in Clause E. Okay. But no such agreement shall be terminated, set aside or modified except after due notice and after obtaining the consent of the party concerned. Please understand, where you are terminating between MD, director, or manager, very clearly you are saying, hey, this is prejudicial to the interest of the company. No way we are going to agree to this. Terminated, set aside. They don't have to get their consent or anything. Whereas, when you are terminating or setting aside or modifying any agreement with any other person, okay, that requires notice. And for modification, you have to get the consent of the party concerned. Okay, is the point, right? This is a very, very interesting and important topic. To understand this, you have to understand insolvency also. You have to know a little bit about insolvency proceedings, etc., etc. Let me quickly start this. Maybe if I can complete it, I'll do. Or else let me keep this for next class. Let me go on to H. So F I have taught G. If I start G now, I'll need minimum 10 to 20 minutes to explain. And if you understand G well, you will understand fraudulent preference in winding up very easily. Comparable. When you come to winding up topic, you will be talking about fraudulent preference then. And you will understand that better. These two are linked topics. So what I will do is, Another 5 minutes is there. I don't want to go here now. Let me move on. Here, they are talking about removal. Here, they are only talking about termination of agreement. Whereas here, they are talking about removal of managerial personnel. Okay, removal. So 242 1H. You remember this? Where we talked about removal of MD. Removal of the managing director or manager or any of the directors of the company. Right? Now, this is a real teeth. Recovery of undue gains from managerial personnel. Where the managing director, manager or director, during the period of his appointment as such, they can recover it. And the manner of utilization of the recovery. See, when I recover it from them, I have to give it to somebody now. So that will be, who will get it? The Investor Education Protection Fund or identifiable victims. See here, Mr. Pradeep's share market shareholders also will be covered. I'm an innocent investor. I bought into this company. That fellow has done all fraud. So we went for a mismanagement petition. Some group went. Later on, you will see class action. So they went. And the tribunal, after hearing the matter, said, yes, this fellow has committed a fraud. And he has, that undue gain has been invested in his own name. We recover it. We seize those assets. We sell them. And that money is bought back. And obviously, it cannot be given to the current management. It will be kept separately, either in Investor Education Protection Fund, or it will be given as a repayment to identifiable victims. Okay. So anybody who is genuinely affected can apply to the fund, and the fund will give them the whatever compensation has been determined, they will get it. The managing director or manager, the manner in which the managing director or manager of the company may be appointed subsequent to an order removing the existing managing director or manager. So we remove the managerial personnel. Now we have to appoint a new guy now. How he'll be appointed, the qualifications, what care should be taken, how he'll be selected, that can be. Because the problem is the managing director. He has created so much fraud and so much problems. So in order to, control him, we will have to do something. So this is one thing. And appointment of nominee directors. Okay, good. So appointment of such number of persons as directors who may be required by the tribunal to report to the tribunal on such matters as the tribunal may direct. This is appointment of directors by tribunal. We saw all this when we discussed appointment of directors, qualification appointment of directors. This is the section we saw, 242 1K, where tribunal has the power to appoint directors. For what? For safeguarding the interest of the company. They will be the watchdogs. They will be the eyes of the tribunal, sitting in the board, reporting to the tribunal on what is happening. And so, because the tribunal is a quasi-judicial body, the tribunal member cannot come and sit in the board. So they will appoint directors to represent them, nominees, who will then go every time he attends the board, he'll report. He'll keep on giving quarterly reports or monthly reports, what is happening, how the situation is going on and all that stuff. Okay. So this is the thing. Now, I think I will stop here instead of going there further. We still have to cover this and 2 or 3 other things. And good progress. Thank you. Mr. Sudhir say, sir, the language used in the original is very constrictive. Who is the person behind this drafting? See, I have a feeling it is preceding the independence of India. So, which means who could have drafted it? Broadly, I'm not able to say, but maybe I'll check out and get back to you. Because we had a 48 Companies Act. Companies Act 48. And 1920. And then that was very old law. So then the English had a 48 Act. Our 56 law is the 48 Act of Britain. So who drafted the 48 Act? I have to check up and tell you. I'll just come back to you. Ours is almost the 48 British Act is our 56 Companies Act. Indian Companies Act. The Companies Act. Okay. There was an Indian Companies Act before the Companies Act 1926, 1922. But 48 law was amended in 48. That 48 law is by and large what we have now in 56. Okay, so definitely. Bonijo, sir, there is no clause for minimum capital of company for operation. Even the shareholders of a tiny company with just a shareholder 1 lakh can apply. So even petty issue may be applied for right. Why the tribunal will reject it, boss? Fun. 1 lakh capital company will only apply. Believe me, most of the cases pending before tribunal are all petty fellows only. Small guys only will go to tribunal. Big guys will solve their problem and go on. Mediation, arbitration, something they will do. Guru Murthy and all will come and sit and solve the problem and go. Okay? But these petty fellows only will go there. And believe me, it is a bonanza for the lawyers. Bonanza. Because they will take their own personal money and give. Of course, maybe your 1 lakh is too small, but reasonably big companies, 1 crore, 2 crore and all, they will do it and they will fight. It will be all fun to watch. So long as you are not in the middle or you are not the auditor, you can enjoy the fun. Okay, they won't go for mediation. They will go for only fighting. Okay, Mahabharat war. Everybody should die. Okay, but for nothing. Okay, how much ever people like Vidur and people like Kripa and all will tell, it won't work. Fight. You or me. Mostly brothers, cousins. More brothers also sometimes they cousins. Okay? All the Mughal history will be again replayed in corporate boards. Where, Humayun had 3 brothers. In addition to Humayun, he had 3 brothers. He killed all 3 of them. I don't know if you are aware. All 3 of them. And every time one brother died, Humayun will go and cry. But this is the fellow who killed him. Either in the battlefield or one guy, he poked his eyes. One of the brothers, he poked his eyes. And he made him blind and kept him in the prison and finally killed him. Every time a brother dies, Humayun will go and cry. But fighting will be happening between them continuously. The Mughal Empire is a series of stories of fraternal battles and nothing. Such battles are now also fought in tribunal for petty companies between brothers and all that. It will be fun. Okay, so thank you very much for your wonderful patience and listening, and look forward to meeting you on Monday when we will take up the balance portion of this topic and finish it. Thank you very much. And I also put up an assignment for meetings and board of directors, for powers and meetings. Kindly go through those 5 questions. Inshallah, if time permits, we will take it up in the next class. Thank you. Good night. Bye.